second, folks, please. Thank you. He's not here now, Karen. W2692.
Good morning, Your Honor. Elizabeth Butler, P80956 for plaintiff.
Is Ms. Kind out there?
Your Honor, I've not had Ms. Kind check in on Zoom.
So we adjourned the hearing. She did not bring her W-2 forms for the last 3 years. Or a deed for real property, it says. So we adjourned this with the understanding she was going to provide you with that information, correct?
Your Honor, we did get some documents, and I'm just appearing today to tell the court that we're satisfied for now.
Oh, okay. All right. I'll just make a note then.
Didn't mean to interrupt you.
You're fine. Defendant did not appear, but provided documents. Regarding creditor's exam, plaintiff satisfied. We're all set then. Thank you. Have a good day.
Thank you. You as well. Same to your clerk.
Thanks. Discover Bank versus Lori Kidder, 2500498.
Good morning, Your Honor. Dylan Clark, P88474, here on behalf of plaintiff.
Good morning, Mr. Clark. How are you? Well, today is the 26th. Do I have Lori Kidder here? Ma'am, you're going to have to straighten that out. I'm going to give
Yes, Your Honor.
You're going to have to straighten out your video, please. There you go. How are you?
Good. How are you?
Thanks. Your name?
My name is Lori Kidder.
Counsel, what's this case about? It's just a credit card?
Yes, this is just a credit card debt, Your Honor.
Ma'am, if you owe this amount, it's $1816.72 plus cost. Do you owe that?
Yes.
Okay. You want to go in a breakout room with Mr. Clark? Can you pay this?
Your Honor, if I may, we already had a chance to speak and we were able to come to a resolution in the form of conditional dismissal.
Perfect. Go ahead.
Defendant agrees to pay a settlement amount of $1,636 in 2 installments. The first installment will be $818 payable on September 29th, 2025. The second installment of $818 to be paid on October 29th, 2025. So long as the funds clear, then we will this dismissal will be deemed without prejudice. However, if defendant fails to make payment as required, then plaintiff will be entitled to bring or reinstate the action for $2,022.02, representing damages of $1,816.72 and court costs of $205.30. And defendant has given me permission to sign her name to the conditional dismissal.
Do you agree to those terms, Ms. Kidder?
Yes, I do.
So you're agreeing that the case will be dismissed, that he can sign your name to the conditional dismissal, that you're going to pay $1818 on September 29th and again on October 29th. And so long as you do so, the case will remain dismissed. If you miss either one of those payments, they can file a motion to reinstate and a judgment will enter in the amount of $2,022. And I think you said 2 cents, right, counsel?
I did, Your Honor. I also mentioned interest.
So you're saving yourself about $364, $386 by making those 2 payments timely. Do you understand that?
Yes, I do.
And again, you agree to those terms?
Yes, I do.
Mr. Clark has your permission to sign your name to that proposed conditional dismissal, true?
True.
Okay, do you have any questions for me, ma'am?
I do not, Your Honor.
All right, I wish you well. Good luck. Thank you, Mr.
Thank
Clark.
you.
Good day.
Thank you, Your Honor.
You too.
Actually, I'll be back at 10, so I'll see you later.
Okay. Bank of America versus Rodney J. Jankowski, 2501448. Good morning, Mr. Burdick.
Good morning, Your Honor. Sazan Barda, P65425 on behalf of the plaintiff.
On behalf of the defendant.
Okay, I'm sorry, you're gonna have to repeat your name. You cut out there. Can you get a little closer to your device?
Sure, Diane Exagararis.
All right. Did you two talk any resolution or you want just dates?
Just dates, Your Honor, at this time.
Right.
Okay. All right, I'll give you 60 days for discovery. So let's just make it October the 31st of 25. No motions heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial. No ADR. Nobody demanded a jury. We're not going to have a settlement conference. I'm putting down 1/2 hour for trial. Witness list due by September 30. You don't have to file a trial brief. If you choose to file it, it has to be filed and exchanged not later than 7 days before the trial date. Jen, I'm going to need a trial date. Why don't you give me for the latter part of November?
Judge, can we do December 1st? We have a jury at the end of
That's fine.
November. Okay.
Jury? Who's demanding juries around here? I'm
Yeah.
just kidding. December 1st at what time?
10:30.
10:30. Okay, you guys?
Great.
Great.
Anything else, Mr. Barda?
No, sir.
Ms. Zagaroris?
Further.
Have a good day. Thank you.
Two.
Thank you.
All right, can you take this one? Capital One versus Brian Phillips. File number 2501456. Brian Phillips.
Good morning, Your Honor. Sazan Barda, P65425 on behalf of the plaintiff.
Mr. Phillips here.
I have not had him check in, Your Honor.
Well, it was scheduled for 8:30, right? It's 9:02. You can take a default if you want, Mr. Barda.
Your Honor, we actually resolved it with Mr. Phillips to the form of a conditional dismissal. However, Mr. Phillips has not returned that conditional dismissal signed. So I was going to either ask for 30-day adjournment to get you this document, but to be honest, I've been having problems getting them back even if we adjourn. If I can submit it under 7-day order and then mail it to Mr. Phillips, and if he doesn't object within 7 days, the court will just enter it, and I can read the terms of that conditional dismissal.
I'll tell you what I'd rather do. I'll just make a note. Parties reached tentative agreement. Defendant has failed to return documents. So I'm going to just go ahead and adjourn it for 3 weeks, and you can either then, if he doesn't respond, you can either take a judgment for the full amount, or you can honor the terms of the conditional dismissal, but they can't not show up for proceedings. Give me 3 weeks out, Jen.
September 22nd at 9.
At 9 o'clock in the morning, okay?
Sounds great. Thank you.
Anything else on this one?
No, sir.
Do you have any other ones here?
No, sir.
All right, have a good day. Thank you.
You too.
All right, LVNB versus Robert Burton, 2501460.
Good morning, Your Honor. Frank Price, P82598 on behalf of plaintiff LVNB.
Mr. Burton has not checked in with me if he's in the.
He's right here. Your name,
Okay.
sir?
Robert Burton.
Did you file bankruptcy?
Yes, sir.
Yeah, we have that as well, Your Honor, on the 22nd.
Oh, so you're just going to submit an order
Yep.
staying the case?
Yep. We were just going to seek dismissal. Yeah.
I'm sorry?
We're seeking a dismissal.
Oh, you're going to just dismiss it?
Yeah.
Okay, you're all set. You're going to submit your paperwork, right, counsel?
Yeah. We will.
Thank you.
Thank you.
All right.
You too. First thing, let's call it. Good morning.
What are we gonna do here? What are we gonna do on this one? 25 CR 478, Kirsten Bailey.
I think,
And this one is, let's see.
I think it's a.
First degree felony, but I don't see any enhancements.
No.
Yes, it's burglary, Judge.
What are we doing?
Yeah, on this particular case for the announcement, I guess it's gonna end up going to your trial docket.
Trial. Okay. There are no priors, right?
Right, the complainant in this case, I believe is the current, she is, you can look, Judge. She's
Boyfriend,
well, right now,
ex-boyfriend.
well, not ex, current.
Well, it says who's
No,
on arrival, officer spoke with the complainant who stated his ex-girlfriend forced entry into his residence by damaging the front door.
right.
You're reading the file right there, Judge.
And then attempted to stab and cut him with a knife she was holding.
That's right.
Well, that's certainly serious, isn't it?
But
Well, let's go to trial on that.
she's pregnant for as we.
And how does that make a difference in the facts?
Well, that's what I'm saying. He, to my understanding, he doesn't want to do anything. But that's, I got you.
Well, what am I saying? What can I do? Go talk to him? I can't.
We've received his non-prosecution affidavit. The state's going to move forward.
Okay, well, it's the state. It's not me who makes that choice. The executive branch of government does. We'll set it for trial.
No problem.
Yamul Burgos.
That's an initial judge. I just want to reset. He's here to reset.
713 Yamul Burgos. Where are you? No, he's not inside.
I talked to him about stuff.
Get him in here so we can move along. I got a trial I got to get to here in a minute. Thanks.
Yeah, I know for a fact he's here because I talked to the wife and dad. Mr. Ham did give me a discovery on. I just need to download that on that. This is our first appearance.
A lot of people dispose of their cases on first appearances.
Oh, we can.
So it's not out of the ordinary.
It won't be high then.
Now he comes with his favorite turn. Come on up. Who's your mule? Yeah, mule. Come on up.
That's it right here with the white shirt.
Which one again?
Right here.
It's it looks like a sweater. That guy's got a white shirt. That's a sweater. That's a good looking sweater. It's kind of beige. You're Yamul Burgos.
Yes, sir.
You're charged with in 25 CR 713 third degree felony deadly conduct. And what are we gonna do on today?
It's a reset to an announcement from initials.
He just got discovery today, Judge.
Mm-hmm. It's 4 weeks good.
Perfect.
Thanks. Get a reset in 4 weeks. Jawan Kolar.
Yes. Same thing. When he's here.
All right, Jawan Kolar. So what are we doing today?
Same thing with him. Mr. Ham gave me discovery on him. So
Here, this is 25 CR 722. The defendant is charged again, third degree felony, unlawful possession of a firearm by a convicted felon. So that carries with it up to 10 years in prison. You want it on an announcement?
yeah, announcement from
Okay.
initial.
All right. Yeah, get a resetting on the announcement. You sit right over there before you leave. We're going to drug test him. Since y'all were loaded with drugs when we arrested you.
This has
Sit over there. Okay, Cedric Marsh. Cedric Marsh. Don't talk to me. You need to talk to your attorney. You're gonna get drug tested and we'll see how it works out, okay? You fail, you go to jail. That right?
I did. Did you mean that?
No, but that's the way it works.
an aspiring route.
That's what bond conditions require. You're not supposed to use drugs, and he was loaded. They were loaded with drugs when they got arrested.
True.
Cedric, that was Cedric.
That's Jawan Caller and
Cedric Marsh, please.
Yeah, I'll talk again.
Thank
I don't
you.
think he's gonna
25 CR 582. Mr. Marsh is charged with a third-degree felony lawfully carrying a weapon in a prohibited place, namely Lamar University. What's his bond? Please. Defendant has failed to appear. His bond is revoked. And
Like $5,000.
his bond is revoked. A warrant is issued for his arrest. His bond is now $20,000. Plus, he must have a GPS device as a condition of bond. Carrying a weapon at Lamar University is or any educational institution is about as bad as it gets. That type of offense. It's a very serious allegation. Lindsay Maynard, third.
He's here.
He was going to accept the plea.
No, well, what happened was you had asked his,
That close.
no,
What do we do?
on him, you had asked him, he was here last.
Yeah.
That his wife bring the medical records.
He's got him.
Right, he brought them up because I think he had some strokes and some heart attacks.
Yeah. I know
And you-
Lindsay.
Right.
I've looked into him. He's
And
trying to get back on his feet.
Yes, sir. Right, and when we were here last, you had asked that he bring his medical records to substantiate, so he has that for you.
Right. Oh, God. Remember, have you ever, do you need these, a copy of these? We can make a copy.
That'd be nice.
I think it's the state at the end of the day, because they're going to make a charging decision on which way this goes. And Lindsay's here. As we know, we're charged with assault on EMS personnel, which is a third-degree felony. That's serious. And I highlighted that sentence in the probable cause affidavit.
Yes, sir.
About what there were some pills ingested and an attempt was made to hurt himself.
Yes, sir.
And but anyway, this is
The medical records that you'd asked for.
well. Let me.
Yeah.
Can we make a copy?
Yes, that's
Give it to the state.
No, that's perfectly fine. That's absolutely
All
fine.
right, here, if we can get a copy of that made, and then we'll give a copy to the state and then give you back those originals. Okay, we're going to reset this for 4 weeks so everybody can look at the information. Okay, get a resetting. Thank you.
Wait, so give you the reset.
Shelby, yeah, just wait for them. Shelby Smith. Shelby Smith. Shelby Smith. Is she?
She's coming.
Is that her?
He's coming.
I think the whole building is shifting. Look at that. 25 CR 706, Shelby Smith charged with a third-degree felony of evading arrest or detention with a motor vehicle. And that's up to 10 years in prison. So we got to treat this seriously. What are we going to do today?
Judge, on this one, I just want to move it from initial to now 4 weeks. Now we're going to
Got it in 4 weeks. Great. Okay, get a reset here. Thank you. Lonnie Linder. Mr. Walker. When you're ready, let me know. Okay.
I think I'm there.
That's really close. Did you see that? That indication was, it was that close. That was a tiny. Lonnie Linder, is that you? Have you seen your attorney today? Is Peter
Mr.
Doyle?
Dole.
Yeah, I haven't
I haven't heard nothing that.
Well, he's supposed to be here at 9 o'clock.
Judge, his health issues, I don't know if he's been released. He's had all those health issues. I don't know where his status.
He's not in here a lot. So
I think I forgot to call him and everything, and he's not answering or nothing.
If you just sign on that X right there.
I know.
We're copying those medical records.
Have a copy of this kind of song.
Yeah, you're gonna. Have to copy.
Yeah, I haven't seen him since I heard he went in.
second one on Butcher, since I have two. I'll print the first one. Good morning. Give me just a second to get these printed out. Are you trustee Butcher? Hold on just a second. We're going to go through this motion first, and then we'll figure out what to do from there, okay? Before we get started, I need you, the best you can, to raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thanks. It's okay. Mine's taking a long time too. It looks like there's a first amended maybe in both also. Or at least in.
I think both of them first.
Okay. And will Ms. Butcher waive the formal reading of the motion in each case?
She will. Yeah.
Okay. So Ms. Butcher, in cause number 20 for DCCR 1732, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2025 for the offense of burglary of a habitation, a second degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 24, DCCR 1733, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2025 for unauthorized use of a motor vehicle, a state jail felony, and that was a 5-year deferred probation as well. Is that correct? Each of these motions allege that you violated your probation. Count 1 in each motion alleges that you failed to report as directed to the probation department March 7th, March 10th, and March 12th of 2025. And is that true or not true?
It's true, ma'am.
Count 2 in each case alleges that you failed to immediately report to the probation officer your change of address. And is that true or not true?
I don't have a change of address.
Okay, so not true. Count 3 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with court officers and staff, probation officers, law enforcement officers, and attorneys. Is that true or not true?
No, ma'am.
Count 4 alleges that you were arrested for the offense of aggravated assault against a public servant, April 29th of 2025 in Harris County, Texas. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 5 in each case alleges that you were arrested for the offense of duty on, that can't be right.
I think it's a misdemeanor version of accident causing injury. So I don't know how that would be.
Duty?
It's
Duty seems like the wrong word,
it
but
probably is, Your Honor.
something about striking an unattended vehicle on April 29th of 2025. Were you arrested for that also? So that's true.
Yes, it's true.
And count 6 in each of those cases also alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle, April 29th of 2025 in Harris County, Texas. Is that true or not true?
True.
Count 7 in each case alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, Texas, April 29th of 2025 without permission. Is that true or not true?
That's true.
Okay. Did you enter your pleas of true in each case to counts 1, 4, 5, 6, and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? Okay. All right, I'm going to find that you entered your pleas of true to counts 1, 4, 5, 6, and 7 in each case freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case so that the probation department can do an updated pre-sentence report. That'll give me more information about you, your cases, and what is going on in Harris County. And then we will come back later for a sentencing hearing. Obviously, the state can bring any witnesses with regard to 2 and 3 if you'd like, Mr. Nichols, at that time. Okay. So, yes, ma'am.
There's no way you can waive the PSI. Everything is still the same, ain't nothing changed. And I was sentenced in Harris County to 5 years deferred probation, and they want me to go to rehab. I have a hold right now because I have to go to Santa Maria for 6 to 18 months. And I want to know, can you please waive the rehab and allow me to be transferred to Harris County so I can start rehab before my baby gets here?
So here's what I can do. I have to get that info, not that I don't believe you, but I need to get that information. When are you due?
November, the end of November.
Okay, so can we get an expedited update? Maybe a couple of weeks? Is that possible? Okay, so I'm going to reset the case for 2 weeks, and that way probation can get with Harris County. We can figure out what exactly went on in those cases, and then I'll determine what to do, because I'm not telling you right now that I'm going to go along with all of that. I mean, you're on 2 felony probations, and it sounds like you've already pled guilty to several other serious ones. Hang on. I don't want you to, I'm going to get the information. I'm going to see what they did, whatever rehab and all of that. And then I will decide on that day if I'm going to go along with that. Okay. All right. So we'll see you back in 2 weeks. Yes, ma'am.
And Judge, it's a transportation code section that's titled duty on
It's so weird.
striking structure fixture, duty on striking unattended vehicles.
Duty on.
That's just how they title the section. And so it's really a failure of that duty is the crime, I guess.
Right. It's just a weird word to use. Maybe there's a definition of duty that I don't know. You said duty? I said duty. You keep saying duty. Sorry. How many times can you say duty? Mr. Rojas, you have Gerardrick Randall. I thought we needed that. This is very straight up. Oh, there we go. It was just stuck on something. It's okay. Good morning. Are you Gerardrick Randall?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
Here we are.
Mr. Randall, in clause number 24, DCCR 0543, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for the offense of aggravated robbery, a first-degree felony, and you were placed on a 5-year deferred probation. Is that correct? Speak up.
Yes,
This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of unlawfully carrying a weapon on May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you were arrested for the offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true? Count 4 alleges that you failed to provide verification of completing community service hours. Is that true or not true?
True.
Count 5 alleges that you did not provide verification of entering and successfully completing the anger management program. And is that true or not true?
Judge, count 6 is duplicative of one of the earlier accounts. We can Abandoned 6.
Okay, state abandoned 6. Count 7 alleges that you failed to provide verification of attending a drug and alcohol awareness course. Is that true or not true? Count 8 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample April 2nd of 2025 that tested positive for marijuana. And is that true or not true?
True.
And then count 9 alleges that you're behind in your court assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 4, 5, 7, 8, and 9 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
And so I have some documents here on the computer that have your signature on them that shows that it looks like you've made an agreement for me to continue your probation and send you to ISF cognitive track. Is that your understanding?
Yes, ma'am. Judge, I realize it's troubling that he's committing misdemeanors and has a gun on him when he's on probation for aggravated robbery. I also know that the court could sentence him up to life for 99 for violating his probation. So this, to me, appears to be a one opportunity for him to get his life right before he's locked up for most of it.
So here's what I want to do. I want to get an updated report. I want a little more information about that new offense, PC and some things like that. And then I'll decide if I'm going to go along with this when we come back at sentencing. So I am going to reset the case for sentencing. I want to get more information about those new offenses and what's been going on, and then I'll determine whether or not I'll follow that agreement. It appears, at least for now, that you don't have any substantial, is there any?
There's
Anything?
one very minor
Okay.
that was provided today for horseplay from
Okay,
himself, Judge.
so it's very important that I don't have a stack of incident reports in front of me when you come back. It looks like you've been doing well. It is very important that you continue to do that because that could influence me one way or the other as well. Okay? All right, we can go back with the bailiff.
Yeah, I think it is. Yeah.
Mr. Kimler, you've got Nathan Lamel. Two cases.
You gotta plead not true to the offenses. See about getting a bond set.
Good morning. Did you file anything for a bond?
Yeah, I've filed a motion for a speed.
So he's gonna enter some pleas in the motion, and then what about the new case?
New case is pleaded not true, and if there's administrative things, we can go through that. I think that they've been doing a lot of prosecution. Or is it?
Computers.
It's not my case, I'm just standing in for.
Ms. Muffin.
Yeah, that's fine. I can't speak to what she intends to do.
I'm sorry, my screen is still loading. There. It's everybody's spinning. Oh.
I don't see a motion for a bond. We'd ask for 3 days. I'm not prepared to report for that advance notice.
Should have requested one in the letter, if not the motion itself, on the notice letter.
Request for probation bond and speedy hearing
Revocation hearing, yes, sir.
was filed August 18th. Let me just go through this motion first.
The same one always filed.
Mr. You're Nathan Lamel? Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So
All right, Mr. Lamel, in cause number 24, DCCR 0826, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of evading arrest or detention with the use of a vehicle, 3rd-degree felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of burglary of a habitation, April 26th of 2025. And is that true or not true? You weren't arrested?
Well, he was arrested. But
That's what the allegation is. And I'm not, anyway, y'all, I don't know why they've changed them to just arrested, because being arrested isn't really a violation instead of committing the offense. All of a sudden, all these motions are different. Y'all might want to take a look at that. They're not alleging that they committed the offense.
I apologize, Your Honor. He was arrested, so that would be true, but I don't think it's a violation.
All right, so count 1, you're pleading true to? Okay.
You were arrested.
Count 2 alleges that you failed to avoid injurious or vicious habits as directed. I don't know what count 2 is either. No, just don't worry about it, because it doesn't say what it was. And so I don't think that is an accurate, I don't think I can go forward on count 2. Count 3 alleges that you failed to report to the probation office March 5th and April 9th of 2025. And is that true or not true? Count 3 is true. Count 4.
Just to be clear, I think what he said was it's true that he called in. So I don't know that he was.
Did you report or did you not report on March 5th or April 9th?
I'm not sure. I think what he said was you didn't report, but you called in.
I don't need to know that. I need to know if you reported as directed on March 5th and April 9th of 2025.
We'll play not true. I think he's not sure.
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true? That's marijuana, THC. Did you test positive on May 1st? Speak up.
Not sure.
Okay.
Not true.
Count 5 alleges that you were at a location other than your residence at 3:01 a.m. on April 26th of 2025. And is that true or not true? Count 6 alleges that you tested positive on May 1st of 2025 for alcohol. And is that true or not true?
Not true.
Did you enter your pleas of true to counts 1 and 5 freely and voluntarily? And because those 2 counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence.
I think you pled not true, not to 5.
1 and 5?
That's my understanding. That's
He
what I wrote
pled,
down.
No, 5 is 3:01 a.m. I thought he said,
Not true.
not true.
I wrote down not true.
oh, I'm sorry.
He's
So,
only played 2 to number 1.
Right.
okay, so you're saying that it is not true that you were at a location other than your residence at 3 o'clock in the morning on April 26th?
When you were arrested, that was your residence or wasn't your residence?
Oh, that was my residence.
He's saying it was his residence that he was arrested at, that's what he was saying. So it's not true.
Okay, count 1 then. All right. So I'm going to reset your case for a sentencing hearing. Obviously, the state can bring any evidence with regard to the allegations that you pled not true to. Also, y'all might want to make a note, go through if there's going to be any amended motions. Looks like I've seen several like this that need to be addressed.
It doesn't appear that the offense is alleged, Your Honor,
It's not at this point, correct?
but there's a non-prosecution file for that.
That's,
so
I
that
don't,
may be
that's,
part of it.
all right. So, we'll get an updated pre-sentence report in this case. And so Mr. Kimler filed a request asking that I set a bond in this case. Give me just a second before I get into that to go. I'm going to take a look, for the record, I'm going to take a look at the probable cause affidavit and cause number 25 DCCR 0744, which is that new case. So give me just a minute. Yes, ma'am, it's unagreed. I printed it. It's easier for me to read in person. Mr. Kimler, do you have any evidence with regard to that bond?
His ability to post the bond, Your Honor, is that what you mean? or-
Yeah, any evidence with regard to your request for a bond?
Well, just that he's on, I believe he's on the third. And, what's your financial situation? Not too good. You employed, or did you lose your job because of your rest?
I had a job that I love to do for the rest.
Where were you working?
I had just started.
I can't, if I, don't make me tell you to speak up again.
I would just say he doesn't appear to be an absconder, in just a few days. It seemed to be.
Well, my issue, I mean, regardless, I guess at this point, until we have more information about whether or not the complaining witness is going to go forward, is that it appears as though
Domestic dispute, Your Honor.
well, he had already been trespassed, warned by the officer, I believe that same day, left with his mother, and then the allegation is he came back and then was aggressive with officers. And that the allegation is that there was a window that was broken and coming through a window, so that doesn't.
She I think the victim, the alleged victim's present, Your Honor, if you want to.
I renew the state's position that we weren't prepared to go forward. In fact, on the bond today, in fact, there's a copy of that letter that Mr. Kimler references. You may have a copy there, but I don't have a copy filed. We asked for at least a couple of days to.
Did you just send that to us, or did you e-file it?
It was e-filed. I don't know if she tagged. I mean, I don't do that.
You got to make sure they have notice of that. So at this point, what I'm going to do, hold on just a second.
She is present.
And we're not prepared.
Yeah, but they haven't talked to her or prepared for anything.
I don't understand why they didn't get a copy of the motion that's been filed.
Well, it was
It wasn't a motion.
a
No, there's
letter.
There's a motion filed.
We have neither a motion or in file.
Well, that's their problem, Your Honor. I mean, that's not mine. He's in jail. I mean,
Well, if it was e-filed and sent to the correct people, then I don't know that it's necessarily their problem or an electronic problem or a problem that your office didn't send it to the right person. So we're not,
But it was e-files. My point is it's on file with the clerk. It's on file.
the state has to be aware of it. Just hang on a second. I see that he's in jail. It's a jail docket. I also have some concerns whether she's here or not with what was going on, because just because she says she didn't want to prosecute doesn't mean that I think she's safe with him doing what this allegation is after he was trespass warned from going over there. Yeah, I guess when you do need to make sure, I guess I have it from the 18th, a request for reasonable probation bond and speedy probation hearing comes now, blah, 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 asking for it. An order was attached as well. So somewhere it got either lost or something wasn't done correctly one way or the other. Doesn't matter at this point. We're here. My bigger issue is probably the same issue that the state's going to have. I want them to have time to talk to her. If she's going to file something and it changes the status of this, then we'll deal with that at that time.
She has filed a non-prosecution.
You have that in the file? Okay.
And one final thing I'll say on this is, it's one thing to file, e-file something, but it's a whole nother thing to make sure that you hit the tab or,
I've gotten there too.
Yeah,
I've already
initiate
said,
service.
I understand. And that's what I'm saying. If the right service wasn't sent, then it's an issue on your side that they didn't get it. Make sure it's done correctly.
To Ashley. I mean, you can see on the e-file notification.
That it was sent to her.
To Ashley.
Okay, so it was sent. Is Ms. Malfino upstairs?
Yes, ma'am.
All right, let's get her down here real quick, please.
All right, let's go.
No, that this was Miss Holiday and then we just found this.
That's it for Reagan, Jeff.
Mr. Marsh's lake.
That's good.
Marsh's lake status.
That's correct.
Yeah.
Thank you.
See you later.
Miss Holiday.
Not anymore. I just did.
Documents, correct? You need to put 0.
People are sensitive about that.
They want to hear what you got to say, Judge. Ironically.
Yeah. Very interesting.
Okay, Mr. Cullen, is that you on? Where's his file? His file color? See what? And your attorney is who? Langston? Where's
Mr. Adams, left.
No,
Oh,
yeah.
no, sorry.
Be fair. We got THC marijuana in the system. He knows it. He knew it. Yeah, you can just tell. What's his bond?
Hold on, I'm 100%.
Yeah, hold on. So we got first fire we got to put out right now.
But I signed for professional bail bond. They didn't have, remember that the only thing they told me was nothing. I ain't have no curfew.
Yeah, you're committing a crime on my watch. That's illegal. That's illegal, sir. First thing on your bond conditions, don't commit a crime. Yes.
That's $8,000.
Okay. Your bond is revoked. It is double to $16,000. Plus, you must have a drug patch on you so that I know whenever you fail, and it will keep doubling every time. This is not a responsible way to handle your case when you're looking at 10 years in prison. So quite naturally, you get high and come to court with drugs in your system. That's irresponsible behavior. That's not the way to fix this mess.
You're done.
All right, those are the orders of the court. I'm going to reset this for 2 weeks or another hearing, because when they're high, I'm not going to have a hearing because they're not acting responsibly. And I don't want somebody to say, well, they were high on drugs. How do they know what to respond in a hearing? Until you sober up, you're going to be in jail. And that's the way that works. And every time we test you, it'll keep going up and it'll cost you money. But it's a foolish thing to do, and you pay for foolishness. All right. I'll reset it for 2 weeks. You're in custody. And then there's this one.
That's Mr. Marsh, who was late.
Oh, he showed up.
Yeah, I need. This was.
How many can stay for those that we're gonna have now?
Okay.
We're gonna bring these first.
You're Cedric Marsh? Come on. This last one was.
That was Javon.
Javon. Yeah. Okay. What did we do with Ronnie Linder?
Have you reset that? That's a PK.
Okay, thank you.
Thank you, Chair.
All right. You're Cedric Marsh, charged with this third-degree felony, unlawfully carrying a weapon in a prohibited place. And what are we going to do today?
Just 4 weeks, Judge, and I'll try to make it out.
Okay.
I think you had increased his bond, but now will you rescind that?
Why did I do that? For nothing. Oh,
It was late, and Judge, frankly, I think you felt like the bond was inadequate because of the circumstances. Because you did not just double it like you normally do. This is the person that had a gun out at Lamar University, Your Honor.
yeah, that's
And in my personal
disturbing.
opinion, it's not adequate.
That's disturbing to say the least. Yeah. All right. Just have a seat right there before you leave. That's him, and then we'll see what happens. But his bond is, what was it originally?
It was 5,000, Judge, which, like I said, I think that's the reason.
Well, that was some official said it. I'm going to, yeah, it will stay 5,000. But we'll see what happens here. Are you going to pass the drug test? You know, you're not. All right. Let's see what we got.
Well, I already know the answer. Peace.
You gonna stand by?
You want me to stay?
Yeah, please. Yeah, please. This doesn't take long for the test. And he's already admitted he's gonna fail. I'm getting a sense of on this stuff now. I'm beginning to sniff it out, and
Okay, here's what it is. Another day in the trenches.
in paradise. Hey, while we're waiting, I need to speak to the state's attorneys on a matter.
Oh, go ahead. Just be loud. Yes, sir.
In 25 CR 582, as you know, you were charged with the third-degree felony of unlawfully carrying a weapon at a prohibited place, Lamar University, which is carrying a weapon at any institution of learning is a most serious crime. I mean, people are there to learn in a safe environment, not to have weapons around. Are you kidding me? But nonetheless, you tested positive for drugs. You got THC, and marijuana in your system. What's his bond?
5,000.
Yeah, it is now $20,000. Plus, you must have a drug patch as a condition of bond. Also, I want a GPS device on you. I don't want you on any school. Are you going to school right now?
Yes, yeah.
Where?
Yeah, I see online, but
online.
He had trespass warnings not to be in Lamar at the time in which this happened. So his
Yeah.
propensity is not
All right.
follow that
Yeah.
news.
I want a GPS device on you. You get near Lamar University or any other school, and you'll sit this one out until we just resolve this case. You'll sit in jail.
Yes,
If I've got to force you to do the right thing and keep people safe, I'm going to do it.
yes,
But you ought to be a grown up enough to act more responsibly than this. And yes, you're looking at 10 years in prison. I wouldn't want a day in prison. But
It's $20,000.
it's $20,000 plus a drug patch plus a GPS device. I'm going to reset this for 4 weeks, one way or the other. That is all. Thank you, sir. We're interested in. Thank you. All right, let's get ready for trial. And thank you. The state's attorney. Before the court made findings.
Let's work together.
Yes. Counterclockwise.
I got the.
You want me to boost you up there? I'll tell you, no, the other counterclockwise.
I'm thinking, let's work together. Which way, Judge?
Counterclockwise.
My arm's
This way?
not long enough to reach that.
Thank you.
Is that good?
Yes.
Voting where you want it, Your Honor?
Yes.
Good.
Yes. All right. Good morning, ladies and gentlemen. We are ready to proceed here as in this case, cause number 22-39960, the state of Texas for Armando Alvera. Stand by. And the defendant, as you know, is charged with the second degree of accident involving injury or death. The defendant has been found guilty as the defendant waived a jury trial for the guilt or innocence phase of this trial. Pleaded guilty before the court. The court made findings that the defendant voluntarily, knowingly, intelligently entered his plea of guilty to the second degree felony. And now we are proceeding to the second phase or the punishment phase of the trial. First thing we're going to do is swear all of you in as jurors in this case. Do you and each of you solemnly swear or affirm that in the case of the state of Texas versus Armando Alvera, you will a true verdict render in the punishment phase of this trial according to the law and the evidence, so help you God? Lower your hands. Ladies and gentlemen of the jury, by the oath that you have just taken as jurors, you have now become officials of this court and active participants in the public administration of justice. This is a great honor in a self-governing democratic republic that we live in. If at any time you cannot clearly hear the proceedings, please raise your hand. Let me know. I want to make sure that you can hear clearly the testimony from that witness chair and also see clearly the exhibits that may be handled and admitted in the courtroom here in this galley. If at any time you cannot clearly hear the proceedings or see them, let me know. No one may discuss this case with you during your service as jurors until you go back together to deliberate amongst yourselves. And likewise, don't feel offended if you happen to run into the attorneys in the elevator or out in the hallway and they do little more than nod to you. To maintain the integrity of the jury system, the law prohibits them from speaking with you until the end of this trial when you are released from all these instructions. Lawyers always like to get input or feedback from jurors at the end of the trial. What you thought was impressive, effective, what you didn't think maybe was effective or impressive. They like to get feedback. It helps them be a better trial attorney. If someone does contact you or tries to contact you about this case while jurors, please report that at once to one of our friendly bailiffs. And likewise, don't discuss the evidence in this case with the your fellow jurors until the end after the presentation of the evidence when I instruct you and you go back to deliberate on a verdict in this case. You may take notes if you wish. Some people like to do that. If you choose to do so, those are for your purposes only. You can't show those notes to others, but they can use to refresh your memory of what you may have recorded. And also, don't go to any of the locations referred to by the witnesses in this case or perform any type of individual investigation of the facts. You will receive all the evidence necessary for your deliberations here in the courtroom. And likewise, don't look in books, encyclopedias, dictionaries, or go to the library or review courthouse records in order to obtain information over and above what is presented to you during the trial. Please listen carefully, as I know you will, to this testimony. No testimony will be read back to you or presented back to you during your deliberations unless you disagree about a specific statement by a witness. Sometimes during a note to me during deliberations, we would like a transcript of the testimony of witness Joe Blow. You won't get that. But you can request particular segments, short segments of the testimony of a witness that can, of something maybe you're disagreeing over what they may have said. I can get that to you, but it's important to listen closely the first time because the making of transcripts and sending back to you is very limited under the rules. Now, your oath states you will render a verdict only on the evidence submitted to you under the court's legal rulings, and the evidence you may consider will consist of the testimony of witnesses from that witness chair. Evidence will also be presented in the form of physical objects or documents that we call exhibits. During the trial, attorneys make objections. And when an objection is made, it is necessary for the court to rule on it. People have asked me, what is it you've done in your life that helps you in your job, do your job as a trial judge? And I tell them, 10 years as a basketball official. This is so much similar. You have to know the rules and you got to apply them fairly. It's just, there's not 1,000 people shouting at you during a contest. So during the trial, when attorneys make objections, I must rule on them. Let's say a question is asked by one attorney, the other attorney objects. If I overrule the objection, the witness will answer the question. If I sustain the objection, then the witness will not answer. But it could be asked in a different way that meets with the requirements of the rules of evidence that we follow. And one of the things lawyers do is from law school onward, we have sets of rules that we follow. And Texas Rules of Evidence. Okay. This is a compilation of the rules that dictate how evidence is properly administered in a trial. it's, you don't just go, here's a pen, we want to admit it. That's not going to get it. Every item that's admitted, whether it's testimony or exhibit, has to meet relevance and reliability before it can go before you, the jury, for your consideration of how much weight and credibility it gives. So here's the rules of evidence. This dictates the formality of how evidence is presented and admitted in court. I'm very sensitive about this. I was on the rules committee that wrote this. Next is the Texas Penal Code, and I'm going to. Penal Code is right here. This is the compilation of the laws that dictate what constitutes most of the crimes. Most crimes that we deal with in the state of Texas are found in the Texas Penal Code, but a third of our cases are drug cases, and that's in a different code, the Controlled Substances Act. So those are the two basic sets of compilations of rules of law where crimes originate, how the legislature dictated what the elements of the crimes are and what are the punishment for each crimes. Now, how does a case move through from the beginning to end? That's in the Texas Code of Criminal Procedure. And it not only deals with what goes on in a trial, how procedurally things are handled in a trial, but how are criminal cases handled properly procedurally from the time they are investigated and then brought to the executive branch of government, the district attorney's office, and from
Good morning, Your Honor. Andrew Cates, P78292 for LVMV funding.
Good morning. Ms. Ferrari, you have to start your video.
Hello,
Tell me your name. Good morning.
Christina Ferrari. Good morning.
All right. So, this is your, I'm telling you, counsel, this e-filing is for the birds. But at any rate, this is a motion to set aside default judgment, correct?
Correct.
You want to go ahead and proceed?
I'm sorry, Your Honor. I have never dealt with anything like this before. The card was stolen and I was in Florida. I didn't know if I should get in contact with the police there because I didn't want to have to go all the way back to Florida for court. So I just called the credit card companies that I knew of and tried to fight it on the Credit Karma and everything like that. I've been dealing with it for years. I've gotten rid of a few of them, but there is no police report. This is the first time anything like this has ever happened to me.
Default judgment was entered April 10th. Why didn't you respond to the complaint?
I did, and I guess it was sent too late. So that's when I appealed it. I showed up for court because I still received the court notification. So I was there and I entered a breakout room and a lady told me that they hadn't received my letter in time.
Judge, yes, her answer was received after a default judgment was entered by about 14 days.
Mr. Cates?
Yes, Your Honor. Essentially, the plaintiff's position is that This case did have enough traction in the previous steps to where we did do some discovery, and fraud packet was sent out to the defendant, and the defendant never returned the same. Attempts were made to contact her. They didn't go through. And now the defendant is coming back with a motion to set aside the default. And even if the court takes the good cause at face value and grants on that, the meritorious defense has never been established. And quite frankly, without a police report or some sort of, investigation done, I mean, there's no way to verify anything that she's saying. So at this time, it's the plaintiff's position that there is no meritorious defense. There was no affidavit filed with the motion saying that, she has grounds to prove that this is a fraudulent account. So I would ask that this motion be denied at this time.
Why didn't you file a police report, man? You're saying you wouldn't be able to return. I'm sure they could accommodate you by doing a lot of that by phone call and Zoom. You can't just ignore the fact that a credit card was stolen and wallet was stolen. And
yeah, I listened to my mother, and I shouldn't have. She advised me to wait and that we were in Florida and I'd have to go back. And like I said, I had never dealt with anything like that before. So I took the wrong advice.
Look, I'm going to go out of my way here. I'm going to go ahead and set aside the default. You have 21 days to answer the complaint and provide affirmative defenses. Now, Jennifer, would you prepare the order to that effect, please? Now, listen to me very carefully. If you're going to defend yourself, that's fine. You have that right. But you have to do it properly. You have to comply with the rules. You have to go through each allegation that he has, that they have in their complaint, and neither admit it nor deny it. Either admit, deny, or state that there's insufficient information for you to form a belief as to the truth of the allegation. But you have to do it the right way. You have to raise affirmative defenses. Fraud would be an affirmative defense. But you're going to have to do that within 21 days. I'm setting aside the default. We're scheduling this for a pretrial. I never had a pretrial on this, I don't believe, right, Jen?
That is correct.
Default, so that's what I'll do. Pretrial date will be, give me a date about 4 or 5 weeks out.
October 6th at 8:30.
October 6th at 8:30. Ma'am, you have to respond to them. If you're going to allege fraud, fill out the paperwork.
Yes, Your Honor. When I got the paperwork, it said something about a police report, so I didn't know what to do with that because I don't have a police report.
Well, when did the credit cards get stolen?
It's been so long. I believe it was 2022.
And you never did anything about it?
I just called the credit card companies, and a few of them they canceled them for me.
All right, that's what I'm doing on this. You have 21 days to answer the complaint, okay, and file affirmative defenses, all right?
All right, thank you.
Up to you. Thanks, counsel.
Thank you, Your Honor. Have a great day.
Thanks a lot. Ronald St. Louis versus Brian Marshall, 250-2190R. Mr. Scanlon, your appearance. I just need Mr. Lewis up here. You can come up if you want. You're a party. Come on up here, Mr. Lewis. Tell me your name. Your name?
Brian Marshall.
Counsel?
May it please the Honorable Court, Gerard Scanlon, appearing on behalf of Brian Marshall.
Any resolution?
No, not at all, Your Honor. Can we get a discovery order on this case, please?
Oh, boy. You guys are going to go through all that. Okay, I get it. Give me a discovery order. Pretrial order. All right.
Your Honor, he said there was no resolution. He didn't even ask me of anything. He just said, Rule 28 months. I said, no, I got tools, it's 2,000, and that was the end of the conversation.
That's accurate. My client's not interested in paying him the $2,000 he's requesting, Your Honor. Therefore, we don't have a resolution, so we must enter a discovery order on this case.
They don't have to settle with you, okay? They don't have to do that. I mean, I can't force somebody to settle a case. All right, no settlement conference, no jury demand, 1/2 hour for trial. Witness lists are due September the 30th. Discovery cutoff is October 31. Trial date will be December the 1st at 10:30 in the morning. You don't have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date, okay?
Thank you, Your Honor.
I'll send this out. You should have it next week. Thank you very much.
Have a great day.
Wait, don't go anywhere. Wait, I got a question here. What?
What's a trial brief?
You don't have to file a trial brief. If you want to, it's a time to tell me in writing what the theory of your case is, the theory of the case is, the issues to be addressed. But you have to respond when he files motions. You can't not respond. I let you get away with it this time. From now on, if he files a motion, you have to file a timely response. Okay?
To the court.
To the court with a copy to the other lawyer.
Pass someone to them too, and the court.
Correct.
Okay.
Okay? Thank you.
Thank you, Your Honor.
Thanks, Mr. Scanlon. Thank you. All right, what else do I have out there?
Judge, I have Discover Bank versus Gray, I believe is ready.
Okay,
It's 10 o'clock.
what about this active life and
Your Honor, if you want to call that, they left a message with Tabitha indicating yesterday, indicating that they had resolved it, but we've not received any documents.
are they here?
No one has checked in.
I don't think they called her. They called our court, the chambers.
Yes, they left a message in Chambers on Tabitha's line yesterday, but did not reach out to the civil department.
Who told you that?
I did, they called me Judge.
Discover Bank versus Katrina Gray, 2404417.
Good morning, Your Honor. Dylan Clark, P88474, here on behalf of plaintiff.
Good morning, Your Honor. Jennifer Palin, P0284 on behalf of defendant.
All right, give me a second here. All right. All right, 80284. 88474. How high are P numbers going now?
They're about as high as mine is. Are
there any in the 90s yet?
No.
Crazy. I mean, I don't need to repeat that again. I just feel so old when I see these 88, 89, 87 P numbers. Anyway, what are you guys doing on this? Any resolution?
No resolution, Your Honor. Settlement negotiations are still ongoing. I think we're just looking for 60 days discovery and some dates.
Discovery cutoff, October 31. No date, no ADR. Witness list due September 30. Trial date will be December 1 at 10:30. Nobody demanded a jury. We're not going to have a settlement conference. All motions for summary have to be filed and heard not later than 20 days before the trial date. You don't have to file a trial brief. If you choose to do it, you have to file and exchange it not later than 7 days before the trial. We will get this out to you. Okay, that's it. Anything else?
Your Honor, could you I know you're going to set out the schedule, but what was that trial date again?
December 1 at 10:30.
Perfect. Thank you.
Okay?
Nothing further here, Your Honor.
Thank you, Your Honor.
Have a good day, you guys. Take care. Thank you. Do I have anything else left? Got some people out here.
Judge, I know that Ms. Hart and Langston are in the courtroom. I'm not sure whom else is in there.
What is your names? What are you hearing?
June and April.
June and April Langston? Is that what you
Yeah,
said?
I'm waiting for defendant's attorney on that case. It was set for 10.
They're not here yet?
He's not logged into Zoom yet.
What do you guys have in the back there?
I'm Nikki Hart. Hello.
Yeah, it's 10 o'clock, small claims.
Is Alvarado here?
No, not yet.
I don't expect.
All right.
I have plaintiffs on the other cases, but no defendants yet.
Okay. I'll be back. I'm not going to give it too much longer, though. Why don't you call that lawyer's office on the Langston deal, okay?
I will. Yes, Your Honor.
Here too, 25001-01181. They're both with that case number, right?
That is correct.
And then I have the 2501403R, which is June Langston. Your name?
April Langston.
Your name?
June Langston.
Counsel?
Morning, Your Honor. James Reno appearing on behalf of Alana Concrete.
Okay, so this is just a pre-trial, so I'm going to go ahead and give you dates.
Okay.
I'm going to put both case numbers on here, okay?
Yes, sir.
All right, so. I'm going to give you guys the following. You have until October 31 to conduct discovery. That is the exchange of information. If you want something that he has, you can make a request in writing for it, okay? If you want to take depositions, ask questions under oath, you can do that. If you want to send interrogatories to them, you can do that. I'm going to give you a trial date of December the 1st at 10:30 in the morning. Witness list, you have to file a witness list by September 30 of 25, identifying the names of any witnesses whom you might call. You don't have to file a trial brief. If you choose to file it, it should be filed and exchanged not later than 7 days before the trial date. I don't know how you guys are going to be able to handle this on your own. I'd encourage you to try to hire a lawyer. I'm just being honest with you. There's rules that you have to follow, though, and I want to make sure that you follow them appropriately. I can't appoint lawyers on civil cases.
Okay, so in the first place, we shouldn't even be here because I tried to contact the defendant about the job he did, and he threatened me that he would go to the police if I contacted him again, and he would sue me for $250,000 in defamation. I couldn't go to the police. I had to turn to the person I paid to do the job. He wouldn't let me contact him. He said he would come out with the inspector to inspect the job. He never showed up. So I didn't know what else to do but to file small claims. And then he took it to civil court, and it didn't have to be like that.
Who owns Alana Concrete, Mr. Reno? Who's the principal?
Ronald Takis.
You want to try to talk to these ladies? If you've seen the work, do you have any idea whether the work was performed in a workmanlike manner? Did you see any pictures? Did you talk to anybody about this?
Yeah, I mean, I've spoken to my insured several times, met with them. I've seen pictures, talked to the owner, the son.
They think it was performed adequately.
Of course.
All right. Well, I mean, I can't force somebody to settle a case. That's what you need to understand.
I'm happy to speak with these two individuals. I was going to take their depositions, but I'm also happy to have an informal conversation with them.
Do you want to go talk to him and see if you guys can maybe resolve this or at least get the wheels rolling? I mean, he's a lawyer. He's not going to be sending you threatening emails about suing you for $250,000 if you are contacting him, okay? Do you want to go talk to him?
Yes.
Well, we'll set you up on a device where you can talk to him by Zoom right now. If there's something else to address, you guys come on back in here and Mr. Reno won't leave. If there is nothing else to address, I'm going to let you two talk. I'm going to prepare this pretrial order and we'll go from there, okay? I just want to caution you, you got to be able to prove your case.
I have pictures.
I know, but you can't just, this is no longer informal.
My house is in.
Ma'am, I'm just trying to tell you nicely, this is, you might have the best case in the history of American jurisprudence, if you will, but I'm trying to tell you nicely, you gotta be able to prove your case. And unless you've got a legal background, you're not likely to be able to do that. Maybe you guys want to hire a lawyer. I don't know what to tell you. I have no answers for this. They have the right to remove the case to the General Civil Division, and you have to prove through competent evidence that they breached the contract, that this was not performed in a workmanlike manner. I'm just telling you, it's very difficult for a lay person to carry that burden because you don't know what you're doing. No disrespect intended. There's a lot of things that lawyers and judges don't know what they're doing, but law's not one of those, okay? So I don't know how to tell you that you might want to seriously consider getting a lawyer. I'm going to prepare the pretrial order. You will talk to Mr. Reno. If there's anything else you guys need to address, tell Mr. Reno you want to go back on record and vice versa, Mr. Reno.
Sure.
And then I'll call the case. Otherwise, I'm just going to prepare a pretrial order here, okay?
Okay.
Thank you. Here you go. Nikki Marie Hart versus Marcelo Alvarado, 2502514 SC. Your name?
Nikki Hart.
Is Mr. Alvarado out there, Jennifer?
He is not. There was alternate service performed. You may not have a copy of the tacking proof, but it was tacked on 8/18/25.
Service was proper, right?
Yes.
Raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
Yes, I do.
He didn't show up to defend. Sometimes they'll file a motion saying they didn't have notice. It was alternate service, so it wasn't personally handed to him. But you can go ahead and you can tell me briefly what the claim is about. Briefly.
Yeah, so I do have text message proof. My fiance is here. My fiance worked for Mr. Alvarado. He promised us a truck, said that he was ordering it on an auction website. I do have pictures of that auction website. He said, I need $3,000. So we gave him cash, $3,000.
How long ago was this?
Last year.
And have you heard from him?
No,
Did you make a police report?
we did not.
Tell him I said to go over there, will you please?
What was that?
Make a police report.
Okay.
Okay? I'm gonna give you your judgment, but these guys taking money, I see more and more and more of this
Yeah.
nonsense going on. People taking money and then not showing up and leaving with it. They're crooks, they're thieves. They should be prosecuted.
Yes.
Give me, do you have a judgment form down there, Jim?
Judge, I'm typing it up right now and I'll bring it down.
Thank you. So I'm gonna give you your judgment. It's gonna be for the plaintiff. And it's gonna be you prayed for, how'd you get the 3325?
So I gave him $3,000 cash. He said that, he wasn't, or he sent the truck back apparently, asked for $300 more, 300 and something more dollars, and I gave that to him through Cash App. So the total ended up being the 3,300 and whatever.
$25.
Yes.
And then you have a filing fee of $70, right? Plus another one of 18, it looks like.
Yes.
And how much was your service and process fee?
We hired the PI that.
Yeah, how much did he charge you?
$68.
And Your Honor, there was a $20 motion fee for the alternate service.
So we have 88 plus 88, right? 176 plus the 3325. Am I mistaken on that?
176 in cost?
Yes,
Yes, that would be.
correct, right?
Yep.
All right, so that should be 176 plus 3325, 3501. Default judgment entered in favor of the plaintiff and against the defendant. She's going to prepare that judgment for the record. This was scheduled this morning for 10 a.m. It is now 10:24, so the defendant was given his 15 minutes. I'd file a police report. Don't let these guys do this kind of thing, you. I don't get it. I don't understand. Crooks. Bad. Go file a police report. Good luck.
Thank you. So what is our next steps here?
Well, we're going to give you the judgment.
Okay.
And then after 21 days, you can go ahead, you can, if you know where he works, you could garnish wages, but you have to have certain information. You might want to read online or talk to a lawyer, but essentially you can conduct collection activity. You could subpoena him for a creditor's exam. They can bring all of his deeds, card titles, bank accounts, stocks, bonds, etc., any numbers, verifying numbers of any of those items. And then you can seek to garnish wages, bank accounts, execute on property. Okay?
Thank you.
Maybe he'll get the judgment and know that he's in trouble. I'd file a police report. Don't threaten him with that. Just file one. Okay? Tell him I sent you. Good luck. Thank you.
Thank you.
Because a lot of them are going to tell you this is civil. That's not civil. Somebody taking your money and stealing from you like that. Good luck. What else do I have?
Credit Corp Solutions versus Baker.
Okay. Credit Corp Solution versus Bridget Baker, 2501007.
Good afternoon, Your Honor. Joseph Jamal here on behalf of the plaintiff.
Good morning. Do I
And I have not had Miss Baker check in.
Counsel, you can go ahead and take a default if you'd like.
Yes, I would be seeking a default. Note that we did have a previous hearing that defendant did appear at. It doesn't appear there is any sort of dispute, and I didn't receive a response to our motion. So for now, I will just file a default if that's advisable with the court.
Yeah, give me your breakdown if you would.
Yeah, so, sorry, 1 second here, Judge. Our initial balance damages $1,313.50. And then we have costs of filing fee 55, motion fees 40, service fee 5505. That's a total of $150.05 in fees for a total judgment amount of $1,463.55.
Defendant failed to appear. Default judgment will enter. The amount of the default judgment will be $1,463.55. Appreciate it if you'd send that over this morning. Thank you very much.
Thank you, Judge.
Good day.
Thank you.
Performance Equity versus David Fry, 2502728.
Good morning, Your Honor. James Shirley for plaintiff. We're back.
Good morning.
Your Honor, Angie for performance equity.
Good morning. What do I have on this one again? Remind me.
Nobody have a motion for possession pending final judgment.
Nobody showed last time, right? Is that what happened?
This is our first hearing. We didn't have service the previous time.
And has there been service now?
Yeah, served on August 9.
Okay, so I entered a restraining order initially on July the 29th. At least my colleague did on my behalf, or July the 3rd, rather.
Correct.
So have you had any contact with this defendant?
No.
I have not.
No, this is our second time in court. So with this one, and he didn't show up, so.
So what are you asking me to do now? Let's see. What is this up for? I don't even know what this is up for. Oh, it's just for a motion for possession pending final judgment?
Correct. Yeah, his last payment was made back on April 7 when you ordered him to pay it by 5 o'clock that day. There's been nothing since then.
And that was through his employer. And he had to leave the court and have the employer pay and.
So that's what you want me to do now is enter an order for possession pending final judgment, correct?
Correct.
Yes.
I'll go ahead and grant that motion. You're going to prepare the order, correct?
I will. I'll submit that today.
Thank you very much.
Thank you.
Have a good day.
You too,
For the
thanks.
record, he didn't show up and it is now 10:29. This was scheduled for 10, was it not, Jen?
It was, yes, that's correct.
No, thank you. Thank you both.
Thank you.
Thank you.
And Terry Nolan says hello.
Oh, yeah. He's doing well.
He is.
He's still practicing?
Oh, yeah. He's in there.
Good for him. And what about his brother, Mike?
He retired probably
I know.
10 years ago.
Probably about 8 years ago now,
Yeah.
right?
Yeah, 8 or 10.
Is he enjoying it?
Well, I have not seen him as a visiting judge for a number of years now, so.
Presumably he is then. Good.
Presumably, yes.
Be sure to tell Terry I said my best.
All right, will do.
Thank you.
Thanks.
Mr. Reno, can you please join the breakout room?
All right. What else do I have?
Langston, if you could join the breakout room again. Judge, I have both parties on the 10:30, Haroni versus Randall in the,
Yeah, bring him in.
okay. And then the other 10:30, Havenwick, I don't have defendant yet.
Okay. Havenwick.
Versus Moros.
All right. Matthew Haroni versus Adam Randall Esquire, 2501675R. Your name, sir?
Matthew Haroni, plaintiff.
Counsel, your appearance?
Maureen Ford on behalf of the defendant. Good morning, Your Honor.
What did I do? Strike an amended complaint back on July 29th?
Yes, there was an amended complaint that was filed outside of the time period. And we had filed a motion for summary disposition. The court held the decision on that in abeyance to allow Mr. Haroni to file a motion to file an amended complaint. So that's why we're here today.
I see. All right. What is your objection to his filing of this second amended complaint?
I mean, stated in our response to the motion that we go through that, I mean, each and every claim that he alleges in his amended complaint is futile. They fail as a matter of law. The facts stated in his amended complaint just simply do not support his claims. He cites to many cases in his amended complaint that have, and his motion that have nothing to do with what they're actually stated. And as you know, even though amending a pleading should be freely granted, one of the bases to deny that is if the claims made are futile.
Mr. Haroni?
I would just say that the amendment is about the pleading, not proving at this stage. I would say that my claims are legally cognizable, and I would say Michigan favors resolving them on the merits, not technicalities. I started this case in small claims, and it was the defendant's choice to remove to general civil, and now I'm just following through with what I intended to resolve in the small claims court. In the end, this is about protecting my children.
I tend to agree when I looked at the claims that they are futile, Mr. Haroni. That being said, I'm going to go ahead and grant your motion. I'll allow you to file an amended complaint, and then you can file your response, counsel, your answer, and we'll go from there. I will grant your motion, but where are we with the rest of this?
Your Honor,
do I have any trial dates? Have we had discovery?
No discovery yet.
I don't think so. We filed a pre-answer motion to summary disposition to the original small claims affidavit. And then, like I said, you held that decision in abeyance, which now if you're allowing him to file the amended complaint, that motion is moot. And we're probably in response to this, just going to file another pre-answer motion for summary disposition.
I understand. All right. I don't know what else to tell you. That's what I'm going to do. I want you to file that amended complaints or second amended complaint within 7 days. Okay. File it 7 days. And Jennifer, will you prepare an order on that, granting the motion? And then I'll hear your motion for summary. I have to tell you, I don't remember a lot about what I read before, but I remember thinking that you were hanging on by a thread, Mr. Haroni. So I'm going to do this for you. I'm going to grant this. You got to prove a case. Okay?
Yes.
All right. That's what we're going to do. Thank you both. Have a good day.
Thank you, Your Honor. Have a nice day.
All right. Havenwick versus Morris. 23F153.
Good morning, Your Honor. For the record, Stuart Collis, P49530, on behalf of the plaintiff.
Good morning, Mr. Collis. Is Brittany Morse here?
Your Honor, she's not checked in yet. It was set at 8:30. I don't know if you want to give it a couple more minutes or not.
10:30, you mean, right?
Or 10:30, excuse me, not 8:30.
If it's 8:30, we're both very
It's been
late.
a long morning already.
Believe me, I had an 8 o'clock and an 8:15 and now this, so I get it.
Okay. Yeah, we'll give her a few more minutes. I'll give her at least until 1:45 to show up, okay?
That's fine, Your Honor. It gives me more time to hang out with you.
Good. You doing all right?
I'm doing okay. I just dropped my daughter at college for the first time on Wednesday, so.
No kidding. Where at?
Wayne State.
Wow.
Yeah. So, I mean, I know you remember probably running around the courtroom once or twice, but.
Yeah.
Yeah.
That's
she's,
great. What you want to study?
She's in medical lab science. She wants to go into medicine. She wants to be a forensic pathologist at this moment.
Ooh.
Yeah. So I don't. She says that way there's no malpractice. You can't have problems with dead people. Clearly, she's been raised by a lawyer.
Right. Well, that's great. That's great. Good for her. Yeah, the years are flying around here, Mr. Collis. I don't know where they're going.
I'm not really sure. My son's a sophomore and in driver's training, and I'm just feel like I'm still, that young attorney who walked into the courtrooms and said, "Here I am," and now it's 29 years.
I know. 42 for me. This is crazy.
It is. It's been a long time. I really don't know where it goes, and I'm on my second and third set of judges, that since I started practicing, sometimes 4, whole benches are completely different. I'm like, oh, that's so-and-so's courtroom. No, not anymore.
A judges conference last week, and I certainly have gone from one of the young guys when I was 36 and now to one of the old guys. Definitely on the higher end of the old scale. So there aren't too many judges that have been around for 30 years, but a handful anyway.
Most don't get elected so young. I mean,
I know.
But it's just. Well, nowadays there's a lot more getting elected young, and I don't understand some of these younger judges. I'm trying. I'm really trying. When you think how things have been done, and they get done for so many years, and then you're trying to learn it another way. It's difficult.
I get it. I absolutely get it. Quite a change in the profession, I think, over 40 years. You know that? I think back to when I started as a lawyer back in 83 and 4 and 5 and how times have changed. And then from my beginning on the bench here with our society is certainly a lot angrier.
Yeah.
So it's a very, very sad commentary. I don't understand some people that I don't understand. I just don't get it. The anger, the lack of respect for authority. I'm not talking about me, but I don't care what it is, police. I don't care if it's teachers. I don't care what it is. It's a sad commentary.
Yeah.
Anyway, I'm gonna get off the bench for 5 minutes. I'll come back out and I'll give you your order here. Okay?
Sounds good. Thanks, Judge.
Thank you, Steve.
$200. Thank you, Kelly. No, ma'am, we're good. Mr. Kimler, you've got Gabriel Smith. Okay. So was this a re-indictment?
Yes, ma'am, that's what I was going to tell you.
Is it going to show up here? It says it was.
Let me show you. This is what he filed in the original case, and then they re-indicted the case in the bond, switched over to that one.
So can we get this to show up now in the original? I mean, in the new case?
I can ask him to either redo it, or I can, yes, ma'am, I can get it in there.
Okay.
I will do that.
Okay, let's see. You are Gabrielle Smith. Stand up, please. And this is cause number 25 DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct? Ms. Smith, the best you can, raise your right hand. Do you swear or affirm do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now as far as trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have anyone.
I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
Yes, sir. Just here. Ready to get my charges, I guess. Decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Two, three, yeah, but 2, 3 Ds and 30.
Look, such a big copy of the middle box.
Every time something.
So it looks like okay, there was back in February of 2024, there was a bond forfeiture. And so the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She then entered a plea, Your Honor.
Entered-
It's a PSI bond.
I did
That
at
plea was
one-
then rejected by the court.
Okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess.
for PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out. Okay. And then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000. So I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report,
Court revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you rejected that.
right, and several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at 40,000 on a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. It involved a vehicle. I think the officer had leaned into it and then the vehicle went into motion. And,
Well, how did the vehicle go into motion?
Well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
She scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about. Well, this is good.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got a speedy trial, I guess, so we need to try.
And the 252nd, everything's speedy.
All right.
It will be placed, I mean, is it? It wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
Well,
the,
I guess if the court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
Take 8. Take 8. You want me to do a rejection?
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Goodness gracious. Mr. Matusko, you've got Xavier and Garner. 6 cases. Oh, I don't have, hold on, let me recall that in just a second. Do you have some stuff coming through on Garner? I've got a registration, but I don't have anything else. All right.
Then I'll need to cattle judge up in here.
Okay, that's okay. I'll hold it for just a second. Thank you. That's gonna be a good one. Get rid of 6 cases. Mr. Parker, you've got Jacoby Judge.
Can't remember what I've done.
I know, I just looked up and I've got a line of things ready, which is good. Yeah. Good morning. Are you Jacoby Judge?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Judge, in cause number 24, DCCR 1174, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 17th of 2024 for the offense of obstruction or retaliation, a 3rd-degree felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to provide verification of attending the SafeP program. Is that true or not true?
True.
And then count 2 alleges that you failed to successfully complete the SafeP program. Good grief. These are a mess.
I don't know why they phrase them like that, Judge. I mean.
All right.
He did it twice.
Okay. You didn't complete the SafeP, you didn't complete the SafeP program, right?
No.
Okay. Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Judge is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes.
Right? Good luck to you, sir. You can go back with the bailiff.
It's on there. It's not real now.
Warren Mills.
Judge, I'm going to ask that we reset that a couple weeks. We've had issues with the video. I've got the video, and I need to go with him. He wants to talk to his
Okay.
family.
All right. We'll just do maybe about 3 weeks on
That's fine.
Mills.
Third screen, I believe.
Shaniqua Washington.
Third screen.
Morning. Good morning. Are you Shaniqua Washington?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Washington, in cause number 24, DCCR 2370, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from September 29th of 2024. The indictment alleges you were previously convicted of theft April 7th of 2010, and then again July 12th of 2012. And how do you plead to that charge? And are those two prior convictions true? Did you enter your plea of guilty freely and voluntarily? And because you actually did what they charged you with? Did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a deferred probation. How long?
3 years.
I'm sorry. Can y'all, any problem with me writing
No,
that in?
I wrote it. Well, maybe
It
she
didn't
probably
come
sent it.
through.
She sent it before.
3 years. Okay, so a 3-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Is there any restitution, or were the items
They were
recovered? Okay. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
objection.
It's admitted. Is there any evidence that Ms. Washington's not
No,
competent?
Your Honor.
Other than those 2 that are listed, do you see other issues?
Judge, I see nothing but misdemeanors, so she's got misdemeanor history.
Okay.
We're asking waive for PSI.
We're okay with waiving it, or if the court wants one, we're okay with it. We are on.
Yeah, I mean, if yours,
There is
This-
history.
there is, I mean, the last one that's listed here is 2012.
We've got some other charges
Other than this. Okay, all right, then I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find, did I print that? Do I need to do it again? I might not have. Okay, going to find sufficient evidence to find that you enter your plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. That shows this was an agreement that I followed, so you waived your right to appeal. Probation's going to talk to you before you leave today. It's very important that as soon as you get out, you do everything that they're tell you to do, okay? All right, good luck to you, ma'am. Let's see, Kendrick Williams, 4 cases are called, Mr. Parker. Kendrick Williams.
Your papers are gonna be on there on this day. Just say more, you don't need to work on it right now.
Okay, so we've got.
I didn't write CC on these cases, Judge, but.
Okay. That's fine. And are we going on, are there more than one count? Are we going on?
On the motion, Your Honor?
Second degree.
No, are they all the
Well, the
new
state jail
cases?
that's enhanced and.
The state jail requires its enhancements.
That's the possession?
Yes, sir. Well, there's 2 possessions, Your Honor.
I'm thinking about it.
No, the evading arrest and previous convictions.
I'm just now thinking I may have filled out the state jail paperwork wrong. I'm not positive, but I may have.
Just be patient with me as I pull it and then I'll figure out what we need to do if anything. Okay, are you Kendrick Williams?
Yes, ma'am.
And will your client waive the formal reading of the indictments and also the motion?
He will, Your Honor.
Okay, so there are priors listed, so it is count 1. I'm assuming,
Yes, Your Honor.
at least on the 1075.
But it's not needed. 1075 or 2352.
Okay, just 1076 today.
Yes, Your Honor.
Okay. In cause number 24, DCCR 1075, the state has elected to proceed on count 1 only. It alleges you committed the 2nd-degree felony offense of possession of a controlled substance from February 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? Okay. Give me just a second. In cause number 24, DCCR 1076, you're charged with a state jail felony offense of evading arrest or detention with previous convictions. And is he getting state jail time on this?
No, that's what I think.
So we need all of them.
Yes.
Did you do state jail paperwork?
I don't remember. I'm thinking I've had in state jail paperwork. I've got this one up here. I've redone it. I just don't remember if I did or not.
Okay. So the offense date on this is from February 19th of 2024. The indictment alleges you were previously convicted of evading arrest or detention September 26th of 2007. It further alleges that you were previously convicted of possession of a controlled substance, a state jail felony, September 24th of 2007, and also possession of a controlled substance, a state jail felony, September 4th of 2012. And how do you plead to that charge? And are all of those prior offenses convictions true?
Yes, ma'am.
Okay, let me make that note real quick. This is so much better than paper. Okay, and then in cause number 24, DCCR 2352, you're charged with the second-degree felony offense of injury to a child, elderly, or disabled individual from July 19th of 2024. So that's already a second. Are we going on the other counts as well,
We
or
don't
no?
need to, Your Honor, just count one.
So in that count one only, how do you plead to that charge? And again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In all three of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in those 3 cases.
No objection, Judge.
It's admitted in each of those cases. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in cause number 24 DCCR 1075, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You did it right.
I did?
Mhm.
Okay.
In cause number 24, DCCR 1076, I'm also going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and in that case, find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2352, also find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, let me get the MTRP pulled up.
Judge, counts 1 and 2 include some of the cases we just pled to. The third one was not yet added as amendment, but since we had an agreement, we just go on 1 and 2.
1 and 2, okay. All right, and cause number 21-36841. I have a motion to revoke your community supervision. It shows that you were placed on probation October 13th of 2021 for the offense of assault on a peace officer. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense that we've already talked about of evading arrest or detention with previous convictions, February 19th of 2024. And is that true or not true?
Yes, ma'am. Sure.
And then count 2 alleges that you committed the offense of possession of a controlled substance, February 19th of 2024. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I also have here on the computer in that case some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these papers with Mr. Parker?
Yes, ma'am.
And do you fully understand them also? And you understand if I follow this agreement, you will be waiving your right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all. What you need? Y'all need some? Yeah, I can just give me this. Okay. Bailiffs already know. Okay.
Bam.
It's reset up here. Just.
Amanda Arendt.
Judge, we're gonna, that's, the state is asking that we reset that. This Ms. Maltino's case, she's trying to talk to somebody about, I don't know, to give me an offer.
Okay,
She's asked us to reset.
we'll just do one normal reset on that. Kyla Allen, it's a sentencing, Mr. Parker.
Yes, Your Honor. What I do? No, she can go back. I told you already. Kyla Allen. For sure. So, oh, you gotta get their level of argument, you know.
All right, ma'am, are you Kyla Allen?
Yes, ma'am.
And this is 23 DCCR 0639. Miss Allen was placed on probation October of 2023 for evading arrest or detention with the use of a vehicle. In court, previously entered pleas of true and a motion to revoke probation to counts 1 through 10. I've received that updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections to that report?
None that I'm aware of, Judge.
Not from the state, Judge.
And this is unagreed. Mr.
Correct.
Parker, you may proceed.
Your Honor, all I can say is, these violations are all technical, even though, I understand that they're still serious and you have to follow the rules of probation. She's young, she's 19 years old. I think being in jail has opened her eyes, and she wants to complete probation. She has quite a bit of time behind this, and my deal was, take the time. She said, I don't want to do it. And she's sincere. She says, I want to prove to myself and prove to everybody else that I can complete this probation. And she has the opportunity. She has a job waiting for her. She gets out, and she's requesting this stay on probation. And she'd like to address it for the judge.
Go ahead, ma'am.
I just want to say I own up to all my wrongdoings. I do. I know it was wrong. I knew it was wrong when I was doing it, and I regret it. But I want to prove that I can do better, and I'm not the person that I got to be. I'm young. I want to build my relationship back up with my people, make it stronger, build my trust. Just do the right thing, make it right before it's too late.
Thank you, ma'am. Mr. Coleman?
Your Honor, this is Mr. Smith's case. I'm under the understanding that Mr. Smith made a 3-year offer in this case. I am cognizant of the fact that recommendations from probation department on the last page states that while the defendant's violations are mainly technical in nature, this officer is not inclined to recommend continuation of supervision at this time. So with that, my position is the same as Mr. Smith's, that should be revoked from some jail time.
Ms. Lopez, do you have anything to add other than what's in the update? So, Ms. Allen, the only thing that I'm inclined to do if I continue, you are young. You don't have a lot of criminal history. This is your first felony, no misdemeanors. Of course, you're young, but you were actually certified as an adult for this, which is, I don't know, certifying on an evading is a little, I guess it's because she was so close to age, but still that's. So here's the thing. You're not going to go home today, okay? If I continue you on probation, which you don't want a felony conviction. At this age, it changes your life in a very negative way, but you obviously need some, in my opinion, just a little more help to make better decisions. And so what I'm going to do is find that you entered your pleas of true to counts 1 through 10 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and send you to prison. I'm not going to do that today. I'm going to continue you on probation, but I am going to order that you now enter and successfully complete the cognitive track of the ISF program. So you went to the substance abuse track so that you could get tools to stay clean. This track helps you make better decisions, helps you grow up. It's hard at 19 to make the decisions that you need to make to be able to stay on this probation, and this is meant to help you. And so you'll go from jail to that program, you'll get out, you're still going to be on probation. You will be on 0 tolerance probation. That means if you make another mistake, Ms. Lopez is going to send something over. There's going to be another motion. I'm going to look back at this. Mr. Coleman and Mr. Smith are going to remind me that they asked for prison time this time, and it's probably not going to be the 3 years. Do you understand?
Yes,
I hope you take advantage of this opportunity. All right. Good luck to you, ma'am. You can go back with the bailiff. Come back for a second. Well, I just want to make sure of something else. I want to make sure you understand something else. That if you get incident reports in our jail or in ISF, that will be a violation of your probation. And you may not ever make it to ISF. So if you are if you're going to say things to the correctional officers, not do what they say, and tell them that you don't care about getting a write-up, but say those things in a lot worse ways, then you're going to go to prison. And you're not going to go to prison for 3 years. They're just there doing their jobs. If you follow the rules, they'll probably leave you alone. If not, their job is to make you follow the rules. And if you can't follow the rules in our jail, then I don't assume that you can follow the rules on probation, which you're kind of showing a pattern here. So it's time to grow up, change all that, or you're going to prison. It's that simple. Understand? Okay, go back with the bailiff. I don't know how I did that. Okay. Bobby Clark, Mr. Parker.
Rejection. Cheers. It's rejection. My wife's been home 24 hours in 4 weeks. She sent a text to one of our friends. She said, I don't know when I'm coming back to New York. She's serious. She's serious.
You're like, hello.
I mean, being a bachelor's not easy. I'm telling you.
You're gonna
I'm
have
not very good at sitting at home by myself.
Yeah.
I have to go.
That's not a good thing either.
No.
Good morning. Are you Bobby Clark? Speak up, please.
Yes, ma'am.
And Mr. Clark, in cause number 25, DCCR 0802, you're charged with a second-degree felony offense of indecency with a child by sexual contact from March 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? Speak up.
Hold on, hold just a second, Judge. Yeah, this is what I was.
Oh, I screwed up, Judge.
Wasn't 4, it's 12.
He had 4 here. It's 12 years. And I didn't, well, I'm assuming you're going to want to reject that.
Okay, so
But I didn't know.
I was wondering.
Yeah,
Make sure, no.
that makes sense. I was telling, I think it's a very good offer.
It was, yeah.
Yeah.
But that was, apparently that was his old case and I didn't see down below where he.
Okay,
I
so,
didn't see the bold.
so Mr. Clark, the offer in your case is actually 12 years. And I'm assuming since you wanted to reject the 4 that you want to reject the 12. Is that correct?
Yes, ma'am.
And so again, I just want to make sure you understand the possible consequences if you go to trial and are found guilty. The punishment ranges between 2 and 20. The option right now is for a 12-year term in prison if you wanted to plead guilty. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial? All right, I will get that done. Is there any reason to believe that that offer would change? So I want to make sure also you understand that after today, unless there's some new information that comes up that the lawyers don't know about, I will not accept this plea agreement. You understand? Speak up, please.
Yes, ma'am.
Okay, and so, Mr. Clark, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who can begin preparation for trial a little quicker. Is that okay with you? So, Mr. Parker, you're released. Mr. Clark, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you go back with the bailiff. Mr. Matuska, Von Zell Hall. Morning. You working on the other one? Are you doing paperwork on Garner still? Huh?
We've done it, Judge.
Oh, y'all already done it?
Yes, ma'am.
Okay, I see. All right, perfect. Von Zell Hall.
I missed the opportunity to tell you, I told you so earlier. I really regret it.
Did you?
It was a cap and they got permission and we were up to the day. Meant to.
You should, you got to take advantage of those
I know,
opportunities.
that's it.
I give them to y'all, so.
But it also would have been like the first hello. Maybe Ashley wasn't mad, so I didn't tell you, so they didn't. So I really shouldn't claim it.
It's okay. You're here for her. Good morning. Are you Von Zell Hall?
Yes, ma'am.
And Mr. Hall is charged with the offense of murder in cause number 24, DCCR 1747. And what is the announcement?
Your Honor, we've received a plea bargain offer that we've been unable to reach an agreement on that offer.
Okay.
And I've informed Mr. Hall of that offer today. It actually has come down a bit. But, I've updated him on that. Again, we haven't been able to come to an agreement.
Okay.
And I see no reason why it would come down any further, Your Honor.
Is that a new rejection that
Yes,
you
Your
have? Okay, if y'all will sign that so I can get it over here and that way I have that. What's the offer?
It's 35 years.
So, Mr. Hall, if you don't want to take that offer of 35 years and you want your case to go to trial and let a jury decide, sign that document real quick and then we'll get it set for trial.
And Your Honor, this is not a cap. This is straight.
Okay. Well, your options are to take 35 years in prison or to go to trial.
So if I sign this, I'm accepting it?
No, if you sign that, that's the rejection that says you want to go to trial, but you don't want the 35 years. If you want to plead guilty and take the agreement for 35 years, there's some different paperwork y'all can do this morning and we'll get that taken care of. But if you don't want to take that offer, then we'll let a jury decide.
And I don't know if it's on that rejection, but I did discuss a possible 40-year cap of Mr. Matuska. If he wants to talk about that.
Do you want to talk?
I told you that.
So either you want to take the 35, take a 40-year cap and let me decide. I could give you 40, I could give you less, or let a jury decide if you're guilty and what your punishment is. That's your options.
Reject that or discuss.
Take a 40-year cap.
Okay. Well,
Yeah, I'll go do that paperwork. I'll hold it for the paperwork then. So I'll delete this. Oh, wait, there wasn't anything. You can
No, they
delete it
hadn't
on your,
sent it
y'all
to me
hadn't
yet,
sent it yet.
so-
Okay, I'll hold it then. Let me, well, Mr. Matuska, I'll let you take care of that and then I'll do Garner in that one when you're finished. Get you all taken care of. Let's see. Ms. Holmes. I don't, oh, did he? Let's see. What was that on? Gabriel Smith. It's here. Mr. Kimler on Gabriel Smith. Gabriel Smith. I know, I need to do the rejection. Yes, please, ma'am.
She looks like it.
Okay, again, you're Gabrielle Smith. And Ms. Smith, in cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Muffino, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here. If any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes,
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have two sequenced, it would make you habitual. Do you understand?
If she has one, it would boost her up to a first.
Yes, sorry. So if you have one.
Not understanding what they mean.
Okay, so listen very carefully. You have several felony convictions out of Louisiana. Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life if there's one prior conviction. You understand? Answer out loud. So
yes, ma'am.
Okay. If there's two prior felony convictions that happened, not all of the, I know there were several that happened at the same time, right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are two that happened at different times, then it means you could be considered a habitual offender here in Texas. And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count one, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years and what your possible consequences are if you go to trial. Do you understand all of that? Okay. And do you want to reject that offer and have your case set for trial?
Yeah, I want to reject.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes to trial. So it's not we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I haven't, so I can't think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for.
You have to decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If y'all do it again, you'll have to do it again. Okay. All of her, if you want to see that old PSI, it's got all those listed. We could get you a copy at least of that page, I'm sure.
I had a real question with Louisiana felonies and the judgments. Sometimes the judgments are problematic for It depends on which parish.
Okay. Well, y'all figure that out. Do you need more time than a
No,
week?
that's fine.
Ms. Holmes, you're sitting over there so quiet in the corner. I didn't even see you. You've got LaKendris Addison.
Good morning.
Good morning. Let's see,
And
this
Judge,
is a motion.
We have an agreement on this case.
Okay.
On count one, I'm gonna drop January 2022, February 2022.
Hold on half a second.
Oh,
Let me
sorry,
get that pulled up so I can make those. Okay. Count one.
And if it's okay with the court, we can proceed just on count one, but I was gonna drop the January of 2022 and February 2022. He was taken into custody in Louisiana during that time, Your Honor.
Okay, got you. Okay. Good morning. Are you LaKendris Addison? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
I'm sorry, the motion.
Yes, ma'am. Yes, ma'am.
Mr. Addison, in cause number 21-36633, I have a motion to revoke your community supervision. Shows that you were placed on probation September 15th of 2021 for the offense of burglary of a habitation. And that was a 10-year term that was suspended and you were placed on probation for 10 years. Is that correct? And then count one alleges that you violated your probation and the state has amended that. Count one alleges that you failed to report as directed to the probation department October 5th, November 3rd, and December 2nd of 2021. And is that true or not true? True or not true? Count two alleges that, oh, I'm sorry, you going
If
on
it's
just
all right
count
with
one?
you, we can, Your Honor, if it's
Okay.
okay with you.
State abandons 2 through 5. Did you enter your plea of true to count one freely and voluntarily? And because it's actually true. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Addison is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Let's see. I gotta figure out how to do, the other day I figured out how to do a strike through. I gotta figure out how to do that again.
Ma'am.
Toy Hill?
Paying $35.
Mhm. Good morning. Are you Toy Hill? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hill, in cause number 25 DCCR 0650, you're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation from January 24th of 2025. And how do you plead to that charge?
Guilty.
January, did I say February?
You said January 20th.
January 24th, 2025.
Yeah.
Is that, are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years.
Yes.
You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hill is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position based on the nature of the plea agreement with regard to bond reduction?
Just for the court's information, I show a criminal history that includes a 4-year deferred on an injury to a child and a simultaneous violation of a protective order for 1 year probation, an assault, which was a misdemeanor, a resisting, and a theft, misdemeanor. I would have some concerns.
What is your relationship now with Cheryl Johnson?
That's her mother. It's real good.
Okay, so let me ask you this. If you are released, when you're released from custody, where will you live?
With a friend of mine, I'm in this client, 4555 Reed Road.
Reed?
Reed, R-E-E-D.
Uh-huh. And where's that? What city?
Off of, Highlands, it's off of Highlands, it's Reed Road, but it's in Beaumont, Texas.
It's in Beaumont. Because I want to make sure you understand that, at least for now, when you get out, you will not be able to have any contact with your mom, okay? And that's going to be very important, because if you do, if I let you out while we're waiting on the pre-sentence report and you have contact with her before we ever come back for sentencing, I don't have to accept this agreement, and things could be a lot worse. Do you understand? It's very important. So what I'm going to do, Ms. Hill, based on the plea agreement, is reduce your bond to $1,000. Okay. If you make that bond, you have a condition of that bond that you have to live at 4555 Reed Road with your friend. And if there's something changes and you need to live somewhere else, get with Ms. Holmes so that we know that. It is also a condition of that bond, if you make it, that you have absolutely no contact or communication with Cheryl Johnson. That means in person, obviously, but for now, that also means any contact, communication. Don't send her messages, don't text, don't email, don't Snapchat, don't, whatever it is, no contact. You understand? Okay. Even if she tries to say, it's okay, let's talk, I want to talk to you, you have to say no, because you're the one who will end up back in jail. Okay. So if for some reason you don't make that bond, probation will come talk to you at the jail. And then when you come back for sentencing, you would be released then. If you make that bond, then you also have to go straight to the probation department so they can do that report. So it's important that you do everything. They'll talk to you today and give you that information of where to go and all of that, okay? All right, you can go back with the bailiff. Can win, Ms. Holmes? You good over there? Good morning. Are you Can Win? Will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Wynn, in cause number 25, DCCR 0750, you're charged with the second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for an 8-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wynn is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond reduction?
There's quite a few misdemeanors, Your Honor, for burglary of vehicle and trespass, among a couple other things. We don't see any other felony cases. This burglary is against property owned by his mother. I don't believe it was her residence. I believe it was the place she owned. He went there and essentially stole TV. So I do have some concerns, but his criminal history is not particularly extensive, Your Honor.
Just sounds like it's some of the same things, though, that I have some.
Correct. It's mostly burglary, several burglary vehicle charges, several trespass charges.
All right, I'm not going to adjust the bond at this time, just in case I want to do something up front based on that misdemeanor history. All right, we'll get the pre-sentence report, and then you'll get sentenced at the next court date. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Two cases are called on Courtney Wiley. Those are both MTRPs. If you'll do the second one.
Judge, just so the court knows, because he was just asking, it looks, there's almost all of those misdemeanors are from about 15 years ago, except for a trespass last year.
Okay, come
So I
back.
just wanted to make the court aware of that.
All right, so here's what I'm going to do. Mr. Nguyen, I am going to reduce your bond in your case based on your plea agreement to $1,000. If you make that bond, a condition of it at this time is that you have no contact with your mom. Okay, you cannot go near her, any of her properties. Do you have a place to live? With your brother? Okay, so now there may be a time when you can have contact, but at this point, because she's the victim in this offense, you are to have no contact, no communication. Obviously, that means in person, but it also means sending messages or text or anything like that. Do you understand? And what'll happen if you make that bond is the very first thing you need to do is go straight to the probation department so that they can do that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Okay, you can go back with the bailiff. You have both of them? Thanks. Okay, Courtney Wiley. Good morning. Are you Courtney Wiley?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
Yes, ma'am.
Ms. Wiley, in cause number 22-40872, I have a motion to revoke your community supervision. Excuse me. It shows that you were placed on probation March 1st of 2023 for the third-degree felony offense of harassment of a public servant in a correction or detention facility. And that was a 5-year sentence that was probated for 5 years. Is that correct?
Yes, ma'am.
And then in cause number 22-40873, I also have a motion to revoke your community supervision. This shows you were placed on probation March 1st of 2023 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. That was also a 5-year sentence that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you were arrested for the offense of public intoxication June 22nd of 2025 in Jefferson County. And is that true or not true?
Yes, ma'am, it's true.
See, that's another one. Count 2 alleges that you provided a urine sample June 23rd of 2025 that tested positive for cocaine and marijuana. Is that true or not true?
Yes, ma'am.
True or not true?
It's true.
Thank you. Count 3 alleges that you failed to comply with the program guidelines and rules of the Safe P Aftercare program. Is that true or not true?
Yes, ma'am. It's true.
And we can stop there, Your Honor.
Did you enter your pleas of truth, thank you, to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am, I did.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes?
Yes, I did.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tender's number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Wiley is not competent?
No, Your Honor.
All right, ma'am, I'm going to find in each of your cases that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 22-40872, find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 22-40873, also find counts 1, 2, and 3 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes.
Okay.
Good luck to you, ma'am. You can go back with the bailiff. Latrick Williams, what are we doing on Latrick Williams?
Mike, one more time, that was Phillips, and I hadn't had a chance to talk to
Okay.
Phillips.
All right, I'll reset Latrick Williams, and if you need something and Philip's still out, just get with Ms. Malfino or Mr. Coleman or Mr. Nichols. I'm sure they can stand in and help you out with that if he's still out. Okay, Mr. Matuska, on Bonzel Hall, let's do him first. It may help me on Garner. Depends, the ones that he's pleading on Garner, it may be helpful for me since there's several to have the indictments printed, please. Okay, again, you're Bonzel Hall, correct? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hall, in cause number 24, DCCR 1747, you're charged with the first-degree felony offense of murder, and that is from, hold on a second. August 10th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska? The papers on the computer that you just signed, did y'all go over those? Did he explain them to you? And do you understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like y'all have decided not on the cap, but on the.
That's correct, Your
Okay.
Honor. And despite what he said earlier, we changed our mind to
Okay.
the original 35.
All right. Do you understand also, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Hall is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Matuska. You also should thank Mr. Matuska because he worked out an excellent deal for you on this type of case. And I can assure you, if you had gone with the cap, things would have been a little bit worse. Do you understand? Go back with the bailiff. Xavier Garner. Oh, I just did it. Just made the noise. All right, there's 3 of them, it looks like.
We'll have 3 cases, Your Honor.
Yeah,
It's only on 3 of them?
The others will be dismissals.
I'm sorry, 2324, I thought y'all could still see it, 2324, 0890, and 0891. And then 2324 is the only other one I need, and also a copy of that sex offender registration, please, on that case. I can, I got that, never mind. I just need the indictment. All right, are you Xavier Garner?
Yes, ma'am.
And Mr. Matuska, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Let me look at something real quick. Mr. Garner, in cause number 25 DCCR 0891, you're charged with a second-degree felony offense of robbery. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? In cause number 25, DCCR 0890, you're charged with a third-degree felony offense of obstruction or retaliation from June 3rd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then finally, in cause number 24, DCCR 2324, you're charged with a second-degree felony offense of indecency with a child by sexual contact, 5th of 2019. And how do you plead to that charge?
Guilty. Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And then finally, in 24 DCCR 2324, that's the indecency case, I have here a sex offender registration requirement form that looks like it has your signature with Mr. Matuska's. You understand that as a result of this plea, you will be required to register as a sex offender, right? All right, state tenders number 1 in all 3 cases.
No, Judge.
It's admitted in each case. Is there any evidence that Mr. Garner is not competent?
No, no.
All right, sir, I'm going to find in all 3 of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0891, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0890, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 2324, find sufficient evidence to find you guilty, and at this time find you guilty of indecency with a child by sexual contact. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive.
Defendant failed to report to her courtesy supervising officer in Butler County for a scheduled office visit. And on May 5th, 2025, the defendant failed to report to her courtesy supervising officer in Butler County for her scheduled office visit, resulting in a warrant being issued for her arrest. In general conditions rule number 7, on August 23rd, 2025, the defendant tested positive for benzodiazepine and admitted to the use of the substance.
All right, Ms. Augustus, you understand the allegations?
Okay, yes.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
I don't have any funds right now at this time.
Okay. You want me to
And
appoint?
I've been receiving small attacks from people that are public community officers. There's so many different things that are going on right now with people. And I could not at that time nor now hardly even get someone to speak to me.
All right, Ms. Augustus, let me stop you here
Okay.
for a second. Okay.
That guy
Ms.
raped his
Augustus,
daughter and me for a long time,
Ms.
okay?
Augustus, the question
Yes, he did.
before you, none of that has anything to do with the question that I want you to answer.
What?
Do you want me to appoint you an attorney?
Every time I get an attorney, they jerk around. They're not the attorney I had the whole time I was
The
here
answer
through
to
that
the,
case.
ma'am,
Yes, we'll try again. Yes, we will. But of course,
Mr. Laux is going to hand you a form. You know, part of the problem here is there's too much of this and not enough of this. You need to close your mouth and listen to what I'm saying. Mr. Lawson's handing you a form. It's an affidavit of indigency that you need to sign for me, please.
He had, now I'm placed in another county jail with no funds. Okay, I'm high immune. I don't have low immune. I don't have HIV terms. I don't have things. When this guy that I was married to did this so many different times, he had automatic liver failure. He had been in and out of the hospital because he likes to open people's legs, including his daughter, and touch on women. This is not the only thing he's involved in. His career, he couldn't keep a job. They were firing him left and right. He was causing wrecks in Virginia Public in his semi-truck. He was driving reckless. He was threatening his workers that gave him jobs.
Miss Augustus?
He has a fake account that he's been living off of for years.
Miss Augustus?
Total thief, total convict, total rapist. And this is why I tried to leave him.
All right.
Okay,
Sign
this
the
has
form.
gone on long enough.
Yes, it has.
So I have to sign here and stay in a jail that's stagnated with HIV and everything else around me. So these girls are in complete attack. Do you understand that?
Sign the form for me, please.
On a military operation that has gone completely nowhere. Nowhere. So you sign right here, right?
Correct.
This Erica R. Ingram was a second grade name when I was in school at a Lincoln Elementary School. That was way long, many moons ago. So I come in here, I've tried to get respect, try to have people hear me out. And as long as you get your way, everybody has a shit food day because I can't help people. You should try a white cell program, everyone yourself. I don't know how else to help the community when we were in the middle of a rapture, okay? Things were being washed up. It was a world disaster. I don't know. I've been in the World Trade Center and I've been in the military for miles all the way here, so I don't know. But when I first got here, I was a lot taller. Now I'm a lot less patient and I'm a lot more hurt at things that you guys are foundering food that has HIV crabs and eggs and roach eggs and everything else that you're feeding continuously to yourself daily to people all over the place because people don't want to use bleach or etc. because in jails they know that they're infected so bad from whoring and everything else. So yes, I'll see you again in court when I lay in the bed in this cell that they have me in with nothing. Because I don't have nothing military pay or nothing until someone discusses something with me. Because as a female, as a woman that came to you several times and was so quiet and cried in courtroom after courtroom and scared of you, when I should not be scared of any authority that is the same authority as mine. On a plane wreck victim and everything else that I've been throughout this past 35, 45 years of my life. When my birthday was 79, not 84.
The court will find that.
But I'm every girl on the radio and I'm every girl on the TV. And this is really, really ridiculous.
I'll find that she's indigent and appoint Attorney John Helbling to represent her.
I just don't have anything, and that's all I've been saying. I don't have anything without you. You have nothing without me. But I really remember a Mariah Carey. It's a lot. I can use it all the time.
597879, counts 1 and counts 2. SP 172179, counts 1, 2, and 3. SP 172179, counts 1 and counts 2. And count 3. 2045500, counts 1, 2, and 3. 2072152, counts 1 and counts 2. 2144004, counts 1, 2, and 3. And, the state of Michigan versus Andrew Edmund Greenlee, case number SX44218511.
Sherika Harris, on behalf of the defendant, please state your name.
Andrew Greenlee.
Good morning to you, sir. There's date and time set for arraignment on the bench warrant.
For purposes of arraignment, my client stands mute.
Not guilty on his behalf, will give us $0 bond. I'll put Mr. Green and put you in a breakout room with Ms. Harris. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
Okay.
You're in the driver's seat of a car, sir?
Yes.
Join the room, Mr. Green. Pass the matter. Let's go back on the record with Mr. Gray. Mr. Gray, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we seek a bench trial date so that he might return with documents. And I asked the court to share with Mr. Gray those employment contacts, that help number, for example.
Mr. Gray, do you have an ink pen? An ink pen? Do you have an ink pen? I didn't hear you.
I can't hear you well.
Do you have an ink pen?
Oh, just a moment. Just a moment.
I don't know if he's ready.
Yes, I have.
All right, 313-719-9921. 313-719-9921. The gentleman's name is Mr. Percy Johnson. Percy Johnson, P-E-R-C-Y, Johnson. Anybody that wants to get into the skilled trades, they can just text that number, help. Help, H-E-L-P. Text that number, help, and see if you get a reply back. He should be waiting on calls.
My apologies. Could you repeat that number one more time? You said 791.
719-9921. 313-719-9921. Text that number. Just text the word help.
Okay.
All right, if there's nothing further, Mr. Gray, come back on September 16th and let me know what if anything came of it, all right?
Okay.
All right, best of luck to you. Have a very good rest of your day.
You too.
All right.
This is the city of Detroit, Mr. Berry versus Marcello Marcus Green. Case number SP 1214501. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Green.
Unmute yourself, Mr. Green, state your name and, please.
Hello, Judge Marcello Green.
All right, good morning to you. You indicated to me the last time you were here that you were gonna hire your own lawyer.
And yeah, and I did. So, Your Honor, to be honest, I would take whatever you got for me. It's a few years old, so I was asking the
Hold on. Today is the date and time set for a trial. Mr. Green, I'm gonna put you in the breakout room with Mr. Berry. And Corporal Adams was here. Is Corporal Adams still here?
I don't know where he is.
Ms. Snyder, I don't hear from Corporal Adams. Join the breakout room, Mr. Green. Talk to Mr. Berry. Let us know today is the date and time set for a trial. Join the room, please. Mr. Berry, Corporal Adams was here, but she's no longer here now, so I don't know if she's spoken to Ms. Snyder or not. So see if you can resolve it.
Yes, sir.
Just pass the matter. All right, are we ready on Ms. Gross?
Yes, Your Honor.
City of Detroit. Good morning, Councilor Warfield. City of Detroit versus Charlene Marie Gross, case number Z8095361. Appearance for the record, please.
Attorney Jessica Warfield, P85391 on behalf of Ms. Charlene Gross. Ms. Gross, can you please state your full name for the record?
Arlene Marie Gross.
Good morning to you, ma'am. Today is the date and time set for sentencing.
Yes, Your Honor. I did have an opportunity to review the recommendation from probation. We don't have any deletions or corrections to make at this time, Your Honor. We would like the court to follow the recommendation of probation. However, I would like to ask, Your Honor, there was a recommendation that my client attend outpatient services. I was going to ask if my client could be evaluated to see what her level of care is, to see if she needs the outpatient services. Other than that, Your Honor, we are in agreement with the recommendation. takes full responsibility, is very seriously, and I am confident that she will be an excellent candidate for probation, and she will not see you or any other judge in this capacity ever again, Your Honor.
Okay, anything to say on your behalf, Ms. Gross? You don't have to if you don't want to.
No, I'm satisfied with what's going on.
All right, it's gonna be the sentence of the court to place you on a term of a 6-month probation with review in 3 months. Attend and complete the outpatient substance abuse treatment program, no alcohol during the pendency of this case, and no illicit substances, illegal illicit substances. A random urinalysis twice a month. Attend and complete the alcohol highway safety course. Attend and complete the MAD victims impact panel. View the short consequences film. Pay $100 assessment fee. Pay $15 urinalysis fee. I would pay that each time you show up. Pay a $35. What do they call that fee? The $35 supervision fee. Like, pay the $240 court fine. You'll have some other statutory court fees as well. I believe Ms. Warfield will go through those with you on the judgment of sentence. And I would pay the supervision fee on a monthly basis as well, instead of trying to pay that all at once, because of the court likes your progress and completed all the obligations and consider closing this out early. Have I gone through everything, Ms. Warfield?
Yes, Your Honor. So 6-month term, 3-month review, the consequences, MAD victim impact and highway safety course, 2 times per month testing, random, and fines and costs.
Right, that 6-month date is going to, that's a 1 year.
Oh, wait, that does say 1 year.
Come back in 90 days, November the 25th, 2025. And then we'll assess it, we'll reassess it at that time.
Thank you, Your Honor.
Thank you.
All right, if there's nothing further, I wish you the best of luck. Have a very good rest of your day.
Thank you too.
Just pass the matter. I mean, let's conclude that matter. All right. Let's go back on record with Mr. Marcello Green. Mr. Green, Mr. Berry, what's going to happen with this case? What happened, Mr. Berry?
I was muted, sir. Dismissal, Your Honor, per the prosecutor.
Mr. Green came in with the big talk. He's gonna retain his lawyer, but once he got that price, he said, "I'll just go with the court appointed, huh?"
Because this case is not necessary, Your Honor.
It's not necessary? Well, you find that out now, it's not necessary. Dismiss per city attorney. All right, if there's nothing further, Mr. Green, you still owe quite a bit of money in 36th District Court. So you'll still, I'll dismiss this case. I'll waive the warrant fee. You'll pay any reinstatement fee, all right? I wish you the best of luck. Have a very good day.
I thank you so much. Thank you.
Very well. All right. This is going to be Mr. Berry, the city of Detroit versus Jermaine Lewis Vernon, case number SP 125733, counts 1 and counts 2, SP 142573, counts 1 and counts 2, SP 14257591, C 54960, strike that, C 5496101, SP 1023471, SP 1033451, SP 1095691, SP 1095880, counts 1, 2, and 3, SP 1122469, counts 1 and counts 2, and counts 3, SP 112247001, SP 1148495, count 1, SP 1178975, counts 1 and 2 and 3, SP 1188543, counts 1, 2, and 3, SP 1261576, counts 1 and counts 2, SP 1281390, counts 1 and counts 2, SP 1281499, counts 1, 2, and 3, SP 1299262, counts 1, 2, and 3, SP 1299271, 1, SP 1337501, counts 1, and counts 2, SP 1340121, counts 1, 2, and 3, SP 1357525, counts 1, 2, and 3, SP 135752661, SP 1408206, counts 1 and counts 2, SP 1424626, counts 1 and counts 2, SP 1448328, counts 1, 2, and 3, SP 1507974, counts 1 and counts 2, SP 1594706, counts 1, 2, SP 1594757, counts 1 and counts 2, SP 1616050, counts 1, 2, and 3, SP 1616051, 1, SP 1623513, counts 1 and counts 2, SP 1623514, counts 1 and counts 2, SP 1643811, SP 1643916, counts 1, 2, and 3, SP 1655134, counts 1, SP 1655136, counts 1, 2, and 3, SP 1703646, counts 1, 2, and 3, SP 1703881, SP 1704022, counts 1 and counts 2, SP 1756711, counts 1, 2, and 3, SP 1756714, counts 1, 2, and 3, SP 819909, counts 1 and 2, SP 9926551, SP 9926553, 17 through 9, 6280, counts 2 and counts 3, 20455, 18, counts 1, counts 2, 207, 15239, counts 1 and counts 2, 2144016, 1, counts 1, 2, and 3. Appearance for the record, please.
Elwood S. Berry Jr., on behalf of the defendant. State your full name, Mr. Lewis Vernon.
Jermaine Lewis Vernon.
Good morning to you, sir.
Good morning.
All right, day of the time set for trial. All the officers here on Jermaine Lewis Vernon. Let's start from the top. Whitehead, Corporal Whitehead, good morning to you. State your name, badge number, and department for the record, please. Corporal Rule, good morning to you. State your name, badge number, and department for the record, please. Corporal Spidell was here. He left. Are you still here, Mr. Corporal Spidell?
This is Corporal Rule, badge 3896, Detroit Police.
Good morning to you.
Morning.
Corporal Bennett, good morning to you. Can you state your badge, name, badge number, and department for the record, please? Good morning to you.
Good morning, Your Honor. Corporal Daryl Bennett, badge 4320, Detroit Police Department.
Officer Obey, good morning to you. Can you state your name, badge number, and department for the record?
Good morning, Your Honor. Officer Obey, badge 4276, Detroit Police Department.
Good morning to you. Officer Brian Nelson, good morning to you. Are you still here? He had to go check in. Is that Corporal Hill? Corporal Hill, good morning to you. Can you state your name, badge number, department for the record, please?
Yes, Your Honor. Corporal Anthony Hill, badge 4598, City of Detroit, 10th Precinct.
Good morning to you. Officer Parinelli, good morning to you. Can you state your name, badge number, and department for the record, please? Nello. Officer William Hill, good morning to you. Can you state your name, badge number, and department for the record, please?
Good morning, Your Honor. Police Officer William Hill, badge 3756, Detroit Police Department.
Good morning to you. Officer Bush, good morning to you. Can you state your name, badge number, and department for the record, please?
Yes, Officer Bush, badge number 4781, Detroit Police Department.
Good morning to you. Corporal Rule, good morning to you. Corporal, I'm sorry. Good morning to you. Can you state your name, badge number, department for the record, please?
Good morning. Corporal Kropic, badge 775, City of Detroit Police Department.
Good morning. Corporal McCree, good morning to you. Can you state your name, badge number, and department for the record, please?
Corporal Jamie McCree, badge 2865, Detroit Police Department.
Good morning to you. Officer Amon Rock, good morning to you. Can you state your name, badge number, department for the record, please?
Sorry.
I'm late to the party. Okay, sorry.
All right, ladies and. You're okay. All right, ladies and gentlemen, thank you for being returning on time. Everyone was able to follow my instructions over lunch, correct? All right. At the end of the last session, the state has now rested. The defense is beginning their case in chief. Mr. Oswald, your first witness, please.
We'd call Anthony Cummings to the stand.
Okay.
Raise your right hand. You swear affirm the testimony you'll give in these proceedings to be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
See, water if you need it.
Yes, sir.
Go ahead.
Can you state your full name for the record and spell your last name?
Anthony Cummings, Cummings.
And how old are you?
I'm 26 years old.
In what area of Ohio are you from?
Lorain County.
And where's that?
A little county outside of Cleveland.
Okay. And we knew you were in prison on December 6th of 2023, correct?
Yes, sir.
What were you in prison for? What felony convictions?
Burglary, drug possession, and theft.
I think a weapons under. And
a weapons under disability.
Okay. And what was your projected out date?
September 25th of 2025.
All right. I want to ask you, how do you know Marquise Weatherington?
Well, he has a brother that's from my neighborhood named Thomas. We good friends, and one of his children and a female I was messing with was good friends.
Okay. And how long have you known him?
Known him before I came to prison, like 2 years before I came to prison, I known him. And while I was in prison, we was friends the whole time.
What year did you get to prison?
I came to prison in 2021. He got to lab. We've been friends in lab since I knew him. He just got down there like 7-8 months before.
Okay, what's lab?
Lebanon Corrections.
Okay. All right, so you knew him prior to prison, and then you were with him for how long?
The whole 7-8 months he was there.
Okay. Do you know if Weatherington was in a gang?
No, he wasn't in no gang.
All right. How do you know James Ogletree?
Really don't know him. I know him from the block of being in a gang, but I don't know him outside of that.
What gang is he in?
He's a heartless felon.
Okay. And obviously in prison, you've heard testimony about commissary.
Yes, sir.
So explain to the jury what commissary is.
Well, commissary is food that you can go to the store and buy every 2 weeks. Put money on your books, your family or your friends or a female, if you got any, and they'll put money on your books and you can go to the store.
Why is commissary important?
Well, that's really the only thing that you have for real. Like that's your money in jail.
So you heard the officer say that's currency essentially?
Yeah, that's currency.
So what can you trade commissary for? What can you get out of it?
You can trade commissary for drugs. You can trade commissary for clothes. Anything that you really need in prison, you can trade for commissary.
Are there any rules regarding commissary among the prisoners?
Certain gangs got their own certain rules, but I wasn't in a gang, so I don't know their rules on how they move with their commissary.
Okay, so let's talk about gangs. What types of gangs were in the J Block?
Heartless felons, Cincinnati white boys, gangster disciples, Crips, Bloods. It was a lot of gangs.
Okay, and so do the gangs strike that? Do the gangs stay within themselves, or do they, I guess, cross over with other gangs or other inmates?
No, gangs stay within themselves.
Okay. So you said the gangs have rules regarding commissary. Do you know what those are?
Like, other gangs aren't allowed they're allowed to steal from other people, but not from themselves. So they can take commissary from somebody, but they're not allowed to take commissary from their own gang and stuff like that.
Okay, I presume another gang, otherwise that's going to create a problem.
Yeah, that will create a problem.
So someone like Weatherington who's not in a gang, he's probably more susceptible to people stealing his commissary because that's the gangs, what they do?
Yes, sir.
Okay. And are there many fights in prison on the J Block?
That was the worst block in the prison at the time. That was literally the worst block.
So how often would you see a fight?
Every day, every other day, for real.
And do you know what they're fighting about?
Literally over everything. Commissary, somebody taking somebody's shower, somebody staying in if you don't get in the microwave in time, they might fight you over the microwave. So
are there rules after a fight happens?
Yeah, it's rules after a fight.
What are those rules among the inmates?
Like if you get into a fight in prison and say if you got a black eye or swollen, you don't come out your cell majority of the time to show a CO because you will be considered snitching. Because if a CO see you with a black eye or something, and they got to go and investigate that. Go back, run the camera, see who was in the room, see that you just got in a fight. Now y'all go to the hoe. So they'd be like, all right, you told basically. So you would be considered a snitch.
So you said if you're cut, you stay in your room?
Yeah, if you're cut, bruised, black eye, it's normal for when somebody gets into a fight, they don't come out.
And you heard corrections officer Lay's testimony that they would make excuses why they were cut and they would never admit to being in a fight.
Yeah, they never. If somebody comes out and they got a black eye or a bruise, 9 times out of 10, if a CO asks you, "Oh, I fell," or I hit something or something, like I ran into the wall or I hit the desk in my cell or something.
All right, I'm going to show you this document. Take a look at it. Just tell me what it is, and then I'll publish it for you.
This is a picture of the cell.
And that's J Block?
Yes, sir.
Okay, now publish it and I'll ask you questions.
Just for the record.
Defendant's Exhibit A.
Thank you, sir.
All right, so can you see that on your screen there?
Yes, sir.
All right, now we know this is kind of a mirror image of what Weatherington cell is, correct?
Yes, sir.
Because Weatherington cell had the bed on the left.
Yes, sir.
Correct. Why is this diagram important for the jury to see?
Because it's not big enough for two people to even be in there like fighting somebody. They couldn't even get him out of the cell. Two people. It's not a big enough cell for just two people to just be in there just doing anything crazy.
And you're saying that because when we look at the width of the bed's 2.5 feet, right?
Yeah.
And then the width of the foot lockers is another 17 inches, roughly 1.5 feet.
Yes, sir.
So it leaves about a 2-foot aisle in between.
Yes, sir.
Okay. And that's a fair and accurate depiction of the cell measurements?
Yes, sir.
All right, next I want to talk to you about kites. Can you explain to the jury what a kite is?
A kite is, you can kite the warden, you can kite the head of the block, you can kite anybody that's in charge of the prison, you feel me? Somebody that's on the block, you can kite them like the unit manager. You can send them a kite and they'll respond back to you on a kite. That's how you get a hold of anybody higher than the correction officers that's working on the block.
So you're using kite like a verb, like you kite them. What is it, a request you're making?
Yeah, you're making a request.
What types of requests are you making?
You can request to get a job. You can request to move the block. You can request to, move rooms. That's how you ask them through a kite.
Okay. And did you send kites while you were on J Block?
Yes, I sent kites.
And why did you send kites?
Well, I've been trying to get out of J Block for a long time because of the gang problems and just everything that was going on over there. Like I was going through that for the last 1.5 years that I was over there. So I've been kiting. I'm trying to get out of the block.
Was your commissary being stolen on J Block?
Yes, my commissary got stolen on a couple occasions.
Okay. Do you know by who?
Yeah, like gangs, like when you go to Child or you at Rec or something, you would come back and all your commissary would be gone. And since I'm not in no gang, it was easy for somebody to go in my room and take my commissary while I was gone.
Okay. So I'm going to show you some kites. Just take a moment. Let's see those. Once you're done reviewing, we tell the jury what the documents are.
What?
This is going to be Appendix D, C, D, E.
Thank you.
Yeah, these are all my kites.
Those are your kites that you sent?
Yes, sir.
Okay. And are those fair and accurate depictions of the kites?
Yes, yes, sir.
We're gonna have you identify them. So defense exhibit B. Can you see that on your screen?
Yes, sir.
Okay. And obviously it's your name. What is the submitted date on this?
Submitted day is 9/28/23.
All right. And it says the room, what's the submitted room?
2J10.
Okay. So that's LCI, that's J Block.
Yes, sir.
Okay. And can you read to the jury what you wrote?
I'm kiting again to move over there. I'm 90 days ticket free. I got less than 180 days left until I leave, and I'm trying to stay out the way. I'm in culinary class, and I've been on J for 2 years. I'm trying to stay focused on getting out and doing right, not the problems on J Block. So when you get an open room, can you please consider me moving? And please and thank you.
All right. And I'm showing you, so strike that. Did you get any response from sending this kite?
Yes.
Okay. Were you moved off J Block?
No.
All right, I'm going to show you the next kite. All right, can you see that on your screen?
Yes, sir.
All right, again, it's your name. What's the submitted date?
10/3/23.
And your submitted room?
2J10.
All right, and what did you write?
I'm kiting it again because I asked my unit manager to put in the word because I really been like 8 months ticket free and I had an incident, but Mr. Cole said he can't. He just told me to, I forgot what I said. Kite again. He told me to kite you again and keep it real. I was going on 5 months ticket free and an inmate punched me and I fought back. I only did 4 days in the hole because I defended myself. That was my last hole shot. I really need G Block. I'm under the new law. I can catch extra time. I'm in culinary. I got less than 5 months left. That's why I keep kiting, because I don't want to take another chance of having to defend myself because I'm not in the gang. I complete my class in December. If you move me, I will get a job after that, and I promise you won't have no problems out of me. You can look at the video of my last ticket and see I'm telling the truth. I'm not a bad inmate. I just want to go home with the right mindset. In J Block, it's hard to stay in my room just so I won't get in trouble. Can you please consider me moving to your block? I promise you won't regret it.
And did you get a response after signing this guy?
Yes, I did.
And were you moved from J Block?
No, I wasn't.
Showing defendants exhibit D as a dog. Can you see that?
Yes, sir.
All right. And what is the submitted date
10/4/23,
and submitted room?
2J10.
And what did you write?
I've been on J Block for 2 years. I'm 90 days ticket free, and I got 135 days left. And I'm trying to stay out the way. Can you please consider me moving next time there's a room open? I know A Block isn't any better. It's just my cousin is a porter over there, and he don't get tickets, and he got life. So I would like to see him before I leave. I promise I'm not a problem, and I won't be a problem if you decide to move me. Please and thank you.
And did you get a response after signing that guy?
Yes, sir.
And were you moved from J Block?
No, I wasn't.
Showing you defendants exhibit E. What's the submitted date on that?
10/5/23,
And submitted room.
2J10.
And what did you write?
I'm trying to move to A Block. I got 130 days left. I'm in culinary. I'm 90 days ticket free, and I'm not a problem.
Did you get a response from this guy?
Yes, sir.
Did they move you from J Block?
No, sir.
And the last one, defendants exhibit F. What's the submitted date
10/24/23,
and submitted room?
2J46.
And what did you write?
I don't know if y'all put me on the list, but I've been trying to move for 3 months.
And then what'd you say below that?
I'm like 6 or 7 months ticket free. I'm trying to get over there. I only got 4 months left. I'm in culinary and all.
And did you get a response from this guy?
Yes.
Were you ever moved out of J Block?
No, sir.
Okay. And did you ever express your concerns to Weatherington?
Yes.
And what did you tell him?
We both was having the same problems. I told him about both of us trying to move. We was in culinary together, so we did everything together. So I was telling them about the game problems and them taking my stuff and trying to move out the block.
Okay. And so you said he was having the same problems?
Yes, sir.
Okay. So what did he ask from you at that point?
Well, we was just trying, the only thing we could do, because they weren't trying to move us, was keep kiting and asking to move out the block. That's the only thing we could do. And that's what he was trying to do as well.
All right. Now we know the incident took place December 6th of 2023, correct?
Yes, sir.
Prior to that, was Weatherington having problems with gangs? Like the week before?
Yes, sir.
Okay. What were those problems?
Well,
Objection. It's your say.
I don't know what the answer is yet, so
I'd also argue it's present sense impression. So I'm not offering it for the truth of the matter. That's what he perceived.
let's go a little bit farther, and then I'll rule on the objection. Okay.
Can you ask me a question again?
Yeah. About a week or so before December 6th of 2023.
Yes, sir.
Whether you said Weatherington was having problems.
Yes, somebody went in his room and took his stuff.
Okay. And what did he tell you after that happened?
Objection.
Well,
hang on. I'm going to overrule it at this point. I'm not sure it's being offered for the truth, so I'm going to overrule it.
Well, he told me he wanted to fight one of them so they can. Well, that's the only way you can, for real, or you would be considered food.
Okay, so let's break that down. You said fight one of them. Who's one of them?
One of the gang members that was taking his stuff.
Do you know what gang was taking it?
It was the Heartless Felons.
Okay. And then you said that's the only way to do it, otherwise you're a fool?
No, you are considered food.
Oh, considered food.
Yes.
Explain to the jury what that means.
Well, being considered food, like if you let somebody take something from you one time and you don't do nothing about it, that means all gangs, it'd be open for all gangs to do it to you. So they would consider you food.
So Weatherington wanted to fight a Heartless Felon.
Yeah, he wanted to fight.
So what happened next?
Well, we was in Chow Hall. Well, the day of, we were in Chow Hall, and he told me that he just had a new bunkie. Addison just became his bunkie. And at first he thought when his stuff came up missing that day that it was his bunkie that took his stuff. But while we were in trial, somebody pulled up on him and told him what really had happened. And so he came up to me and he told me like basically that he wanted to fight one of them, just make sure that he don't get jumped or they don't take the rest of his stuff.
Okay, then what happened?
We go back to the block. It wasn't our time to be out at the time. So
what day is this? Is this December 6th yet?
Yes, this is the day.
Okay, this is December 6th, that day.
This is that day.
Okay, keep going.
We go to the block, and while we're on the block, we're not out yet. You know, they lock us down after trial. Everybody goes direct at this point. So we are literally the only people that's left on the block with who else didn't go to rec that day. He told me to make sure nobody came in the room and jumped them and make sure I watched the door. And that's what I did.
So now we've seen the video.
Yes,
we know
sir.
the time frame. It's roughly 7:04. Okay. And you saw the recording with you and Ogletree.
Yes, sir.
How do you connect with Ogletree?
All right. See, Ogletree, he's like one of the head, I guess, or one of them. So at first we really went to him trying to get this stuff back. But I guess in the gang, once they take your stuff, they're not allowed to give it back. So he was the one that was going to catch the one-on-one fight with him. So I told him, I'm just going to make sure that nobody comes in here and jump him. You feel me? We from the same city. We got to stick together.
So the heartless felons sent Ogletree to fight on their behalf.
Yes, sir.
And you were worried other heartless felons were going to jump Weatherington.
Weatherington was too. That's why in the video, when it first came on, you see him standing outside his door. We're outside the camera, so when he sees me, that's when he walks in his room. That's when he knows it's good. He cleans his room out. That's what you do when you fight. You move stuff out the way and clean out your room. So he cleaned out the room, and when he came and opened back the door, that's when I walked down there, and I walked in there, and Ogletree walked behind me.
And then what happened while you were in the cell?
Well, when I first got in there, they was arguing.
Tell me what.
They were arguing because they stole his stuff. And, you know, we thinking like, you know, you're not allowed to steal. That's what we thinking, that gangs aren't allowed to steal. So we like, can we just get the stuff back? Because, you know, we ain't thinking y'all stole it. It's not like they went in there and actively took his stuff. They stole it while we were at trial, when we was out of the room. So they're sitting there arguing back and forth. And while they're arguing, I'm in the middle of two of these grown men arguing. So I'm telling them, I'm not trying to get caught out of place, because if I get caught out of place, I'm going to the hole. So I'm like, man, if y'all about to fight, y'all fight. You feel me? Whatever y'all about to do, y'all do it. Then somebody came and knocked on the door and said, y'all been in here, man, what is y'all doing? Is y'all about to fight? Y'all about to fight. That's when y'all seen somebody knocking on the door, talking into the door.
Okay, when they were arguing, how loud were they?
It was loud, like people on the block could hear them.
How close were they?
That room is little.
So they were pretty close at that point?
Yeah, they was pretty close. I walked in the room first, so I was in the middle of both of them at first.
Okay, so on this diagram, I know, like we said, the bed's on the other side, but at least, so that, I believe that's a touch screen.
Yes.
So if you want to mark where's Weatherington, where's Ogletree?
Weatherington is right here on the back wall. I'd be right here, and Ogletree is right here.
Okay. And so from 7:04 until 7:14,
sitting there arguing about what took place, because another gang informed us who took it, because we thought Addison and his gang, because Addison just moved to his room like a couple of days before. So we really thought that they took his stuff, because how do his stuff come up missing, but your stuff don't come up missing?
and you said they because we heard Officer Creech testify Addison was a gangster disciple.
Yeah, he was a gangster disciple.
And so when you say they, you thought maybe the disciples took it.
Yeah, we thought that, because how do they come in the room and take his stuff but not your stuff?
Right.
It just doesn't make sense.
So for that 10-minute period while you were in there, was there any punches or fighting?
No, they was fighting over because Weatherington had the rest of his belongings in his bag on his bed. So they were sitting there arguing, and then he was like, basically told him like, y'all didn't even take my stuff, y'all stole it. Like, and that's when Ogletree was like, I take this right now. So now they're sitting here like tugging over the bag.
So that's the white bag we see you.
Yeah, that's the white bag.
And do you know what was in that bag?
It was some glasses. It was some Like a couple of soups. It wasn't much because they took his stuff earlier before.
So Weatherington's personal property.
Yes.
Okay.
What he had left.
And at this point, they're arguing, tugging back and forth on this white bag.
Yes, sir.
And then what happens?
So then I tell him, somebody knocked on the door and was like, man, what y'all doing? Like, is y'all about to fight? Hurry up. One of Ogletree's gang members came and knocked on the door.
So that guy we see in the video knocking on the door is a heartless felon?
Yes, sir.
Okay. And then what happens when you, at 7:14, we see you exit?
So when I grabbed the bag, I said, is y'all about to fight? Y'all fight, you feel me? And get this over with. So I walk out the room, they get to fighting, I go and drop the bag off, and I come back to the room.
And that's where we see it takes you about 3 minutes to walk down to whose cell?
I went to I had a heartless felon as my bunkie, so I didn't want to take his stuff into my cell. So I took it to the cell next door to mine, and I dropped it off, and I made sure that my friend that was next door will hold it and watch it while I go back and make sure nobody jumped him or nothing.
Okay. So then we see you in the recording that you walk back to the cell, you go in the cell. When you open or go back in, what do you see?
I go back in, he's over top of him.
Who's he?
Ogletree.
Over the top of?
Weatherington.
Okay. And
he's
punching.
punching
What happened?
Yeah, he's punching him. So I push him off like, man, he's done. He's cool. You feel me? I check on him. He's still like, I really can't really, I'm trying to hurry up and get out the room. I'm really not even trying to get caught in here. So when I push him up off him, like, man, he cool. You feel me? I see that Weatherington is like linked up a little bit, like coming off of his back. And then that's when I walked out the room. And
so let me back you up. When you first walk in, are they on the lower bunk?
They're not on no bunk.
Okay. Are they standing?
No, they're not standing.
Are they on the ground wrestling?
They're on the ground, and Weatherington's on his back, and Ogletree's on top of him punching him.
Okay. And obviously there's recording, but you just made fists?
Yes.
Okay. So he was closed fist hitting Weatherington?
Yes.
Right, left hand, both? What?
Yes, both of them. Like,
okay.
Punching him.
So he was on top and just punching him. Where was he punching him?
He's punching him in his face.
Okay. And how many times did you see him hit him?
See him hit him like 3 times when I walked into the room.
Okay. And did you see any injuries to Weatherington?
At the time, he got dreads like me, so I didn't see none, but I seen like his eye was a little bit puffy and his mouth was bleeding.
Okay. And then at 7:17, we see you exit?
Yes, sir.
Did you say anything to Ogletree at that point?
No, I tried to turn around when we walked back in the room to really check on Weatherington, but when I went to walk back, Ogletree shut the door.
Okay. So then later on, we know now from the recording, roughly 8:12.
Yes.
You go back to a cell?
Yeah, because I really couldn't check up on him when I was in there. I wasn't trying to get caught out of place, and it happened so quick. So when I walked out, I couldn't go and get the door open myself because I'm not in that cell. So I was trying to look for a cellmate, Jason Addison, so he can go and get the door open and check up on him.
Okay, so at 8:12 p.m., what did you do?
I found his cellmate. He was in the phone room. I told him, can he go and check up on him because he just got into a fight. He went up there, he checked up on him, and then he came and got me.
Okay, and when you were in there, did you have contact with Weatherington?
Yeah, I did.
What was that contact?
Well, he was up on Addison's bed when I came in there because Addison, when he came back and got me, he was like, yo, Nick, excuse my language, he was like, your friend basically is bleeding on my bed. That's why he had blood on his cover. He was like, and he told you to come, he told me to come get him. Told me to come.
Weatherington told Addison to come get you?
Yeah, to come get me.
Because Addison's upset with Weatherington that he's bleeding on his bunk?
Yes.
All right, so he's sitting on the bunk at this point?
Yeah, he's sitting on Addison's bunk.
Right. And do you have any conversation with him?
Yeah, I was asking him, was he cool? I gave him some water. He was like, yeah, he cool. And he was like, help me up on my rack. I just want to get on my rack. And
go ahead, sorry.
So when I helped him up on the rack, Addison did help me.
Did Weatherington say anything about his head?
Yeah, he said his head hurt, but I couldn't really see nothing on his head because he had dreads.
Okay. And so you helped Weatherington up to the top rack?
Yes, sir.
Okay, so you got close enough that we know there's some blood do you know if that was Weatherington's blood? We know now.
Yeah, that had to be. That was the only time I came in contact with him.
Okay. And then after he gets on the top bunk, what do you do?
Once I went on the top rack, once he got on the top rack, I went back to my cell because, I'm out of place already. I'm thinking I don't think that nobody is got like real injuries or nothing. Like I'm thinking it's a regular fight. He's gonna be cool. So I go in my room, I lock down like a regular day.
Okay, so let me back you up a little bit for the time period between 7:17 when you leave Weatherington cell to 8:12, that time frame.
Yes, sir.
Did you have contact with Addison?
Yes.
Okay, explain what contact or conversation you had.
I was looking for him because, like I told you, when I walked out the room and I tried to go back, Ogletree shut the door. I can't get the door popped back open because I'm not in that cell. So I got to look for his cellmate. So I'm walking around, I'm looking for his cellmate, you feel me? And I see him in the phone room. When I go into the phone room, I'm like, hey, can you check up on him? He just got into a fight. I wasn't really able to really check and see if he was all right or not. And he told me all right.
Okay. You heard his testimony, correct?
Yes, sir.
He testified something about you trying to pay him to clean up the mess.
Yeah, like.
Did that ever happen?
No, I never. What would I pay him?
Okay. And so the extent of the conversation you had was you said you go check on your.
Yeah, can you go and check up on him? Because he just got into a fight. I wasn't really able to check up on him. I'm not on that side of the range. And I didn't want to get caught up out of place. So I just wanted to make sure he was all right.
All right. Were there any statements about beating his ass?
Oh, yeah, I heard him say that yesterday as well. I did tell him that he got into a fight, but I never said that I beat him up or anything. I said they just beat him up.
Okay, they being?
The Heartless felon.
Okay, so you never said we beat him up. You said they beat him up.
Yes, sir.
Okay. And then did you have any contact with Shaquiz Akeem?
No, that's what was really off to me. I never talked to him.
Do you know him?
I seen him on the block. Yes, I seen him around, but I never talked to him. I know that him and Addison was in the same gang, but me and him, we never really even spoke to each other like that. So yesterday when he said that we knew each other very well, everybody knows me in Weatherington as being friends because we're the only people from Lorraine on that block and not in the gang. So everybody know that we go to trial together. We were in culinary together. We go to the gym together. We cook together. So I really didn't even know him. The only thing that he said correct yesterday, that he knew that me and Weatherington was friends.
Okay. And so then you said you were locked down 9.
Yeah, 9 o'clock.
And then next day, what happens?
Next morning, you could see me when Addison walks out, you could see me talking to him, asking like, is he cool? And he was like, man, I don't know if he cool. So when he said that, I told him, if they come and get you and talk to you, tell them to come get me. You feel me? Because I didn't want to make anything noticeable and be caught a snitch or anything. So I know he was his bunkie. So I said, if they come get you, make sure you come get me. And I told the state patrol and everybody that.
Okay. And at what point did you realize Weatherington was dead?
I was in the gym playing basketball at the time, and they shut down the whole jail. So when they shut down the jail, they said they come through the speaker like an inmate has been passed away. So at the time, I'm hoping it's not him. I didn't get to see him that morning. The last time I seen him, he was alive. So when they shut down the jail, they came and got me from the gym like an hour or two later.
So Shaquiz Akeem said when he looked in the window, he saw Ogletree on top of Weatherington, choking him, punching him. He claims he saw you hit Weatherington twice. Is that accurate?
That is literally impossible. I know that everybody's seen that room. When he said he was on the bottom rack punching him, and over him on the bottom rack, it's a hood it's a top rack over it. These is 2 big grown men. Everybody in this room is 200 and some pounds, damn near, or 200 pounds. So where would I be punching him at if there's somebody over him punching him?
So when you were in that cell and Ogletree was choking him and punching him, you stood by the door?
I was never in the cell when a punch even got thrown until I came back.
Okay, so as you stated, you were in the middle until 7:14.
No, not until 7:14. I was in the middle majority of the time when they were sitting there arguing.
Okay.
Once I grabbed the bag, I moved out of the way, and that's when I was by the door.
And then when 7:17 you return, that's where you see Ogletree.
Yeah, that's when I seen Ogletree.
And you saw Ogletree on top of Weatherington, but on the floor, not the bed.
No, they weren't on the bed. They were on the floor.
Okay. Is there anything else you want the jurors to know about this?
Yeah, like, I know you guys don't know about jail and the rules and everything that go in jail. I know that you guys didn't seen the video and the way that they put the video, but I never ever, I don't even get in trouble. Not no bad inmate. I don't even do stuff like this. The only reason that I was in that cell is because Weatherton asked me to make sure he don't get jumped and nobody take the rest of his belongings. I did what he asked me, and that's why I was there.
No further questions at this time.
Cross. Thank you, Your Honor.
Good afternoon, Mr. Addison, or Mr. Cummings.
Good afternoon, sir.
So I want to start because I want to ask you a little bit about your felonies, because I think you missed a couple of them when you were talking to Mr. Oswald. You're currently incarcerated for failure to comply. Is that correct?
Yes, sir.
2 burglary offenses.
Yes, sir.
For weapons under disability.
Yes, sir.
Obstructing official business.
Yes, sir.
Theft.
Yes, sir.
Possession of drugs.
Yes, sir.
And menacing by stalking.
Yes, sir.
Okay. I also want to talk to you about the kites. Mr. Oswald went through all of these kites, 5 different kites. Is that correct?
Yes, sir.
And all of those kites, he's talking to you, you're requesting to get off of J Block.
Yes, sir.
Not in any of those kites, though, do you complain about getting your stuff stolen, do you?
Not that I recall, sir.
Okay. And the other thing I want to ask you about is because as he was going through the kites and he's like, you're asking to get off of J Block, nothing happens, no one's allowing you to get off of J Block. Is that correct?
Yes, sir.
That's not actually correct, is it? Isn't it true that before this incident, you were transferred to the G Block, to the G housing unit?
Yeah, but that was because of my culinary.
So hold on, because
Yes,
you made it seem very clear to this jury that you kept requesting to get off J Block and they wouldn't let you. But after that last kite, you ultimately did get off of J Block, right?
No, all the kites that he read me that I read to them, I got denied on every single one of them. That's what I was answering to. The kites that I sent, I got denied on those kites. So
Later,
I did not
you did get off of J Block.
Yeah, that was later on, but not to the kites that he read me, sir.
Okay. So let's talk about that. You went to G Block, is that right?
Yes, sir.
Around what time frame?
I really don't recall. It was 2 years ago, but if you know.
Would that have been late October, early November?
Yes, sir.
Okay. And you were in G Block for how long?
Got to be like a week or so, a couple weeks.
And tell the jurors, what is the reason that you went to G Block?
I went to G Block because I was in culinary, and if you have a job and you're 90 days ticket free, you can go to the honor dorm, and G Block is the honor dorm.
How long did you last in G Block?
A week.
And you got written up and moved out of G Block, didn't you?
Yes, sir.
So when you were just telling these jurors at the end of Mr. Oswald's questioning, I'm a good inmate, I don't get in trouble, I don't get tickets, when you finally got what you want, when you were begging to be taken off J Block, according to you, you made it to G Block, a different housing unit, and you lasted 1 week before getting written up, getting in trouble, and being sent back to J Block. Is that correct?
Yes, sir.
Okay.
Sir, may I ask you a question?
No. Let me ask you this, because a lot's been made of the fact that you had an out date that was coming up pretty soon, right?
Yes, sir.
But even though you had that out date coming up pretty soon, you got in trouble in G Block just a couple of months before you were to be released.
Yeah, it was an in-house infraction.
Okay.
It wasn't no RIB ticket.
You still got in trouble, and as part of a sanction, you were removed from G Block and put back in J.
Yes, sir.
Okay. How well did you know Mr. Wetherington's brother?
We're from the same neighborhood.
Okay. And were you good friends with him?
Yes, we was good friends.
Was his last name Wetherington as well?
No, his last name wasn't Wetherington.
Okay. What was his last name?
Lumpkin.
Lumpkin. Okay. But you then knew Mr. Marquise Wetherington from prior to prison, is that right?
A female I was messing with and a female he had a baby with was friends. That's how I knew him.
Okay.
Through them.
Okay. And because of that relationship, then in prison, you two kind of hooked up and kind of looked out after each other.
No, just being from the same city in jail. We not from like none of the major cities like Cleveland, Columbus, or Cincinnati. So our little counties stick together in prison.
Okay. And it's your testimony that at some point he is getting stuff stolen from him.
Yes, sir.
And that you are as well. Is that right?
Yes, sir.
Okay. And it's gangs that are doing this. Is that right?
Yes, sir.
Let me ask you, because you were housed with a heartless felon. Is that right?
Yes, sir.
And so who was stealing your stuff?
Well, before I got, when you see on the kites, I wasn't in that room 2J31. I just really moved into that room because I kited to get, I came back. I left, actually. How you said I went to G. George.
Mm-hmm.
So when I came back, they moved me in that room with the felons. After that, nothing came up missing since I was in 31.
Okay, so once you were in with the felons and you were bunking with the felon, your problem stopped.
No, my problem didn't stop. I wouldn't say that, but I didn't have no problem while I was in that room. I was only in that room for not that long before this incident happened.
Early November to December 7th, right?
Yeah, like I told you, I'm in culinary, so majority of the day, I'm out of the block. I leave at 7 o'clock in the morning. I come back at 10. They lock us down. I go back to school at 11:30, and I get back at 2 o'clock. So I'm gone majority of the day.
Okay. And you are aware that there are no kites from Mr. Wetherington complaining about his stuff getting stolen. Is that correct?
Well, there wouldn't be no kites about anything being stolen. That's why I never wrote a kite about anything being stolen, because that you are considered a snitch. If I write a kite to the COs or to somebody and say, my stuff is being stolen, they got to investigate it. I can say, write a kite and be like, the gang problem is a problem because they know it's infested with gangs. But as soon as I say steal, I'm considered a snitch. So no, you would never say that.
Okay, so you agree there's no kites of him complaining about that.
Yes.
There's no kites from him within the last weeks or months immediately prior to this incident, even requesting to be taken out of J-Block, right?
Well, I'm not on his tablet to know what his kites is, sir.
You had an opportunity to view his kites, didn't you?
No, I got the opportunity. I seen my kites that my lawyer sent me. Them are the ones that I read.
Okay. So he comes to you, and I think when you testified, you said about a week before that he comes to you with this idea to fight. Is that right?
No, a week before the cellmate that he had before Addison ever became his cellie. And this is why he didn't have a cellmate no more. His stuff came up missing.
Okay.
And
so when does he talk to you about this idea?
He told me that day, the day December 6th, that was like the last straw. That's when he told me he really wanted he got to fight somebody. Like he didn't want it to keep happening.
But the last time something came up missing from him was the week prior to December 6th?
No, the last time something came up missing was that day, sir.
Okay. So December 6th, he comes to you while you're at Chow. Is that right?
No, we're in the line at Chow. Yes. And he's telling me.
What does he say to you?
He think that Addison, because he just became his bunkie that week for real, like a day or so before. He think that he took it because none of his stuff came up missing. So he's telling me like, man, I don't know. I think this dude that just moved in my cell, gang members took my stuff. So now we're in Chow and we pull up and they're the ones that tell us who took it.
You say they're the ones that
the gangster disciples. Like when you go in the Chow hall, or the gangs sit with each other, eat with each other. So when we pulled up on them and asked them like, hey, yo friend is in my friend's cell. And his stuff ain't come up missing. Like it's kind of awkward. Like, did y'all go in there and take his stuff? And they was like, nah, Ellen's going there.
What was taken on December 6th?
It was food that was taken. His commissary was taken.
Do you remember what time that would have been taken on December 6th?
Had to be before Chow.
Okay.
Before lunchtime.
So before Chow, the victim, Mr. Weatherington's commissary gets stolen from him.
Yes.
And that would include his food items.
Yes, sir.
Okay. And and we figure out that it's not the gangster disciples, and now all of a sudden we believe that it's the heartless felons.
Not believe, they told us.
The heartless felons did?
No, the gangster disciples told us.
Okay. And so at that point, Mr. Weatherington says what to you?
Tells me like he can't keep having this happen, like he got to fight one of them. So
Okay.
at that time I told him, you feel me? No, at that time he told me just make sure I don't get jumped or nobody takes the remainder of my stuff.
Does he ask you to help set this up?
No, he tells me that the fight was already about to happen no matter what, so I didn't have to set nothing up. He just told me to make sure that, you feel me, he doesn't get jumped and nobody takes his stuff.
Hold on, because I'm confused. When you say that the fight was already about to happen, he thought up until that moment that it was with the gangster disciples.
Yeah, but when he found out that it was the felons and he told me in line, like he about to fight one of them, and he already had it in his mind that that's what he was going to do.
I'm confused because I thought it was in the line that the gangster disciples come up to you and tell you that it's the felons.
I never told you in the line I said in the line, he told me, he was telling me in the chow hall line that his stuff got taken. We walked up to the gangster disciples. That's what I told you. We walked up to their table because they eat together. All gangs eat together. And that's when they told us at that point who took the stuff.
Okay, but then he talks to you about then having to fight the heartless felons, right?
Yeah, he told me that.
And you said that that fight was already set up. So how was that fight with the felons already set up?
It was already in his mind that he was going to fight one of them, but at the chow hall, we pulled up on them in chow too as well. After the gangster disciples told us they took it, we asked them who went in the room and took the stuff.
Okay, just trying to make sure that I follow all of this.
Yes, sir.
He thinks his cellmate has stolen it.
At
He's
first.
telling you that in the line at chow. You guys then go talk to the gangster disciples.
Yes, sir.
They say, hey, it wasn't us, it was the heartless felons.
Yes, they tell us that.
And then you two are like, there's the heartless felon table. Gonna walk over to those guys and see if they took it.
Yeah, we pulled up on him like, hey, did y'all take anything out of his cell? And we was talking to them at chow hall. And the one table, cause it'd be like 3-4 tables. And every block goes to chow with each other. So everybody that's from J. John goes to chow with J. John. So when we pulled up on them at the table, they were low key like laughing about it.
Okay. And so what happens next?
We go back to the block, but this was earlier. We don't come out until later. So my bunkie is a heartless felon. So when we go back to the block and we lock down and we don't come out till later, I tell him like, my dude just want to catch the
Wait,
one.
when you say I tell him, who's him? I want to make sure we understand who we're talking about.
My cellmate.
Okay, so you tell your cellmate, who's a heartless felon.
Yes,
right?
sir.
You tell him my bunkie, sorry, go ahead from there.
No, the heartless felon is my bunkie.
Oh, yes, sorry.
We just pulled up on them in child and they was talking about how they took Weatherington's stuff.
Mm-hmm.
So it wasn't nothing really like, he said at child that he wanted to fight, you feel me? But at that moment, we not in the gang, so you know, we don't know if it's about to get jumped or what's gonna happen when we come out later on. So I tell my bunkie like, listen, it don't gotta be no big nothing. No, he just want to catch the ones with anybody, and that's it.
Okay, so you tell your bunkie, what's his name?
Well, we don't call each other names, like government names in prison, but his nickname was Block.
Do you know his real name?
No, we don't. That's like considered police stuff in prison, calling somebody by their government.
Okay, so you tell him your boy Weatherington wants to fight somebody from the felons.
They already know he wants to fight him. He made that known in child. But I was just basically telling him like, it don't have to be like no jumping situation or nothing. He just wants to fight one-on-one over his stuff.
Okay. And let me ask you a question because I want to make sure that I understand the logic of this. Let's playing this out, okay? So
Yes,
he wants to fight one of the felons because they keep stealing his food.
Yes.
If he, say that happens, say a felon comes in and Weatherington beats the crap out of that felon, how is the rest of the felon gang going to take that?
That's why they went and got the person that they got. Because he was like, they're basically like their enforcer. Ogletree never wasn't even around to have nothing to do with nothing. But they went and got him once they knew that he just wanted a one-on-one fight. He didn't want nothing more. He just wanted to fight because somebody took his stuff.
But that's what I'm trying to understand, because what doesn't make sense is presumably if he wins the fight, the heartless felons are going to come back as a gang and do even more harm to him. If he loses the fight, the heartless felons win and they keep taking his food.
How do you know that? You've been in prison before? Once you set up something and the person or the head of the block who runs that gang okays it, and he says, all right, they can catch the ones. It don't matter if he loses or not. If the head person of that gang says okay, they can catch the ones, ain't nobody gonna jump them. That's what it is. It doesn't go beyond that, sir.
So you thought then by asking for this fight, whether...
I didn't ask for the fight.
No, sorry. When Weatherington asked for this fight, the thought was whether he wins or loses the fight, that should end his food getting stolen.
Yeah, he didn't want to be considered as food. He just wanted to, show that he'd stand up for himself.
Okay. So you tell your cellmate he wants to fight one of the people that was taking his food, and then your cellmate...
No, I don't tell my cellmate that, sir. I tell my cellmate that they already knew in child, when we pulled up on them in child, that he wanted to fight. It wasn't nothing ever put together that it was going to be a jump or if they was going to jump him. I was just telling my cellmate, can it just be a one-on-one fight? That's all he want, you feel me? He just want a one-on-one fight because somebody took his food.
And what was your cellmate's response?
He said that was cool.
And did he tell you who he was going to get?
No, not at first.
Okay. When did you find that out?
Found that out when we came out of our cells that day.
When who came out of their cell?
When we all came out of our cells. See, earlier like what was explained yesterday, one ranger come out in the morning and then one ranger come out that afternoon. We don't come out until that afternoon. So at lunch, it was still morning rec out. We wasn't out until later on that afternoon. So I didn't know who was gonna fight who until we came out of our rooms that afternoon. And we as everybody on the second range.
But all of this was set up that day, right?
Yes, sir.
Okay. After Mr. Weatherington's commissary was stolen?
Yes, sir.
Okay. So you come out of the room. How do we know it's time to fight?
Well, at first, Weatherington, as you can see in the video, when we first came out, we went to dinner. They called dinner first. So when we went to dinner, that's the last chow hall period. So they tell us, they pull up at our table at chow and tell us basically this is
Hold on, when you say they pull up at our table, who's they? Who are we talking about?
Two heartless felons pull up at our table.
Who did?
Two heartless felons.
Heartless felons. One of them Ogletree or no?
No, it wasn't him. It wasn't him. I didn't see, this is what they tell me. Two heartless felons pull up at our table and tell us that just clear out your room. Y'all can catch the ones, and that's what it's gonna be. I didn't know it was Ogletree until you seen in the video when Weatherington was standing outside his door, and you don't got me in the camera. I don't know why that wasn't even shown, but once he seen me and he walked back in the room, I didn't know it was Ogletree until he went back into the room and was starting to clean out his room, that Ogletree was gonna be the one to fight him. He pulled up to the phone room and he was like, you go in there first. Make sure that he got the room clean. I'm gonna come in there.
Hold on. So you and Ogletree are in the phone room together, right?
Yeah, he came in the phone room.
He comes in the phone room, talks to you, and then says, you go in there first and then I'm gonna follow.
Yeah, because I was already talking to Weatherington. You can't go on that side of the range. So once you see Weatherington outside his cell right there, I'm already in the phone room knowing that he's about to clean out his room. And then when Ogletree comes in, that's when I know that he was doing that to be fighting him.
Okay. And what happens? You go in.
Yes, sir.
What do you say to Weatherington?
When I first go in, I really don't get to say nothing because Ogletree came in right behind me. So when they first get in there, I'm in the middle of them, and we're first really trying to get everything back because they stole it. I thought gangs ain't allowed to steal, and he basically said if you're not a part of their gang, they're allowed to steal from whoever. And that's when they got to arguing because he said like Weatherington was like, well, y'all stealing, y'all ain't even taking nothing. Like, how is that tough?
So how long was there a conversation?
They was arguing for a little minute. Now that I see on the camera, it was longer than what it was for real.
Because you remember when you were interviewed by the Ohio State Highway Patrol?
No, I really don't remember. I wish y'all would have came back and showed me my interview like y'all did with Shaquem.
You didn't have an opportunity to watch your interview?
No, sir. Never got to ever. But I know that when I seen the Ohio State Patrol twice, I cooperated with them. I told them everything that I seen and everything that was going on.
Do you remember telling them that as soon as you walked in, Ogletree came in right behind you and boom, he sees the bag hanging up there and he immediately grabs the bag?
Yeah, that's what I just explained to Mr. Oswald as well. They were arguing over the bag and all that, yes.
Okay, so he comes in, and is that right? He immediately comes in, sees the bag and grabs it?
Not immediately like that. He does come in and the bag is right there, but words were said and then he go and grab like, I take this. And that's when they're sitting there fighting over the bag.
Okay. And this was a set-up fight, right?
Yeah.
But it's your testimony today that when he first walks in there, he wants to talk about why you're stealing his stuff?
No, he wanted to get really not why they were stealing it. Like he wanted like they're stealing, they're not taking it. Like, ain't y'all not allowed to steal type? Like really trying to get the stuff back for real and not even really fight for real.
So it was your thought at that point Weatherington didn't really want to fight?
No, I know he wanted to fight, but if you can get the stuff back and not have to fight, because we know that like we ain't seen Ogletree. That's not even one of the people that we were talking to. So basically, trying to tell him like if we can just get the stuff back and not even have to do this, we would rather go that route for sure.
What did Ogletree say?
Like I told you before, he said like you're not in a gang, like we allowed to steal from anybody that's not a felon. Basically, that's what he told him.
And then Ogletree grabs the bag.
Yeah, and they both reached for the bag, and I was in the middle of them when they was sitting there tussling over the bag.
Okay, how long does that go on for?
Going on for a second. Then when I grabbed the bag, somebody came and knocked on the door. That's when, because they was sitting there arguing and screaming, and so somebody knocked on the door. One of the felons was like, man, what y'all about to do? Y'all about to fight or what y'all about to do? And that's when I was like, man, if y'all about to fight, y'all about to fight, man. I'm not even trying to get caught out of place. I'm not trying to get into anything that's going on. So at that point, that's when I grabbed the bag, leave the room, put the bag in my next door neighbor's room. And
how did you get the bag if Ogletree and Weatherington were fighting over it?
I told you that somebody knocked on the door. When somebody knocked on the door and said, man, what y'all doing? Like, is y'all about to fight? Fight. If not, you feel me, get this over with. Like, what is y'all doing? And at that point, everybody's attention went towards the door. Like and when dude said that and the door got shut back, that's when I grabbed the bag and said, man, if y'all about to fight, y'all fight.
You grabbed the bag from who? Because weren't they pulling back?
Yeah, when they was pulling it, like I told you, when they was sitting there arguing over the bag, I'm in the middle of them. Just like I told the Highway State Patrol. I was in the middle of them. We all got the bag. Like this. Everybody got the bag because it was on his bed. So when he went and reached for the bag, Weatherington reached for the bag. Now they sitting here. I grabbed the bag like, man, what is y'all doing, man? I'm not about to be in here with two grown men, you feel me, fighting over no bag. If y'all about to fight, y'all fight, you feel me? And that's when the person came, knocked on the door, was like, man, what y'all doing? Like, if you about to fight, fight. If not, you feel me?
Weren't you worried about taking the bag when clearly the enforcer of the Heartless Felons wanted that bag?
No, I wasn't worried about taking the bag because that's why I was there. For Weatherington not to get jumped and for nobody to take his food. So once I got that out the way and they got to fighting and I made sure nobody get jumped, that's the only reason I was even in there in the first place.
Make sure Weatherington didn't get hurt too bad.
Didn't get jumped by nobody.
And that he didn't lose his food.
And the rest of his belongings that he had didn't get taken.
Okay. So you take the bag, you leave, you put it in another cell.
Put it in the cell next to mine.
Then you come back.
Yes.
I want to spend some time talking about this. When you go back into that cell, describe for the jurors exactly what is going on, what you're seeing, what you're doing. I want to know in as much detail as possible.
When I walk back into the room, Ogletree is over top of Weatherington punching him.
And where are they at positioned in the cell?
They're on the floor. His head, Weatherington's head, is faced by the toilet.
So is that right at the door?
Not right at the door, no. Do you got the diagram? Yeah, so they're like right here, and his head is like faced towards like the toilet right here. So you see the doors right here. So when I walk in, I'm by the door, but yes, I'm by the door when I walk in, yes.
So you walk in, you're by the door, and you see that Ogletree is, Weatherington's on his back.
Yes,
right?
sir.
And Ogletree is over top of him.
Yes, sir.
Is Ogletree on his knees?
Yeah, he's on his knees.
And he's unloading lefts and rights on
And I push him back.
Weatherington's head.
Yeah, I push him back and tell him he's cool, like he's done.
So then you walk in, you see this, you're standing there, you see Ogletree on top of Weatherington, you realize what's going on, he's punching him in the head, you then go over and you push him off?
Like this, like he cool, like, stop the fight.
So you went right up to this heartless felon that's the enforcer, who's in the middle of this fight that everyone agreed was going to happen, and you pushed him off.
Like, not like an aggressive push, like he cool, like how, like if you watch UFC, if somebody's getting punched on and they come and they put in front of you, he cool.
Okay. And so I assume then once you kind of get in between, you're like, he's cool. Ogletree kind of backs up and gets off of him.
Yeah, he stands up, and that's when Weatherington gets to leaning up.
Okay. So Ogletree backs up, stands up somewhere back here. Is that right?
Yeah, he stands straight up.
Weatherington then is up, and he's trying to lean against the bed.
No, he just, like, when I seen he's leaning up, because at that moment, that's when Ogletree, like, low-key walks over him while he's getting up, like, walking out the door to leave.
Okay, and you said that you check on Weatherington.
I really couldn't like thoroughly check on him because we out of place at this time. I just walked in the room, I just seen this. So when I walk out the room, when Ogletree walks out the room and I walk out the room, I'm about to turn back in there to go and check up on him and thoroughly check up on him. But that's when Ogletree shut the door.
But I'm not asking about thoroughly checking up on him. You asked him if he was all right at that time.
Yeah, at that moment I asked him was he cool and he was getting up. Yes, sir.
Okay, and so he's getting up, he's leaning against the bed, and he's saying that he's cool. You're like, are you cool? He's saying he's cool. At that time, Ogletree is trying to exit the cell.
Yeah, he's walking out the door.
And then after Ogletree exits the cell, you're looking at Weatherington, and then you exit the cell. Do you give him water or anything?
No, I didn't give him water until I came back because, like I told you, you get caught out of place, you feel me? You go to the hole. So I'm trying to get out the room. You feel me? And once I see like where the CO is at, that's when I turn back around. That's when you see me try to turn back around in the video, and he shut the door.
What injuries, if any, could you see on Weatherington at that time?
At that time, I just seen his mouth busted for real. And we got dread, so I really didn't see no cuts or nothing on his head or nothing.
Was he fully clothed?
Yeah, he was clothed.
Where did you go after you left?
I was looking for Addison because the door shut, and I can't get the door popped because I'm not in that room. The only person that can get the door open is his cellmate. Okay. So I went and looked for his cellmate, like what you seen on the video, and I tell him, can he go and check up on my friend and make sure that he's cool because he just got beat up.
And Addison, after he does that, tells you what about Weatherington's condition?
He comes back and tell me like, he told me come get you. He bleeding on my bed. Like he says the N-word, but he says like your friend is bleeding on my bed. Like and told him to come get me.
Okay. And so you go with Addison.
Yeah, I go back.
What's the condition of Weatherington at that point?
At that point, he's up on Addison's rack, like linked over. I'm asking him, is he cool? I give him some water.
Hold on 1 second. I want to make sure that I understand. When you say he's up on Addison's rack, that's the first bunk. He's sitting up, like his butt is on the bed?
His butt and his head is down.
His head is down. Mm-hmm. Okay, and what's the conversation?
I just asked him, like, is you cool? He was shaking his head like, yeah. I'm like, do you need some water? He said, yeah, I gave him some water. And I was like, is you cool? I asked him again. He said, I just want to get on my rack.
Was he able to drink the water that you gave him?
Yeah, he sipped the water that I gave him. It was in his cup.
So at that point, according to your testimony, he's up, he's drinking water, he's talking. Is that right?
Yes, he was cool at that point.
And then he asked for some help getting up on top of the bunk.
Yes, sir.
And so what do you do?
I sit there, I help him on his rack. Addison helped him get up on his rack. But before I left, he didn't have no cover or he wasn't laying down or nothing. He was sitting up on his rack, still with his head down. And he was telling me his head hurt.
Did you see, because you said that Addison was complaining that Weatherington was bleeding on his bunk. Did you see blood on Addison's sheets?
His sheets was blue at the time. I didn't really see, I was really focused on Weatherington for real. I really wasn't really even caring that he even cared about his blood on his rack for real. I didn't care about that at all.
But could you see the blood coming from Weatherington's head?
Nah, his dreads is longer than mine. I just seen the cut for the first time like everybody today. I didn't even see the blood coming from his head or anything at the time. I remember he telling me his head hurts though.
So you saw the photographs from the scene, is that right?
Yes, sir.
You saw that top bunk that had blood all over it.
Yes, sir.
And it's your testimony, though, that 15, 20, 30 minutes after this fight, he doesn't have all of that blood down the side of his face. There's not blood everywhere on Addison's bunk.
No, not that I seen. I didn't see blood all over his face. I seen his lips. You feel me? He was like this with his head down. So his dreads was just down. And I'm like, is you cool? Is you cool? And he was like, yeah, I'm cool. Give me some water.
But ultimately, I know he had his head down at first, but you saw him drink water and you helped him get up on the bed.
Yeah, I did not see nothing bleeding from his head though.
So you think all of that blood that ended up on that top mattress, that must have just started bleeding sometime after you guys lifted him up onto that mattress?
No, but you got to think, he was in that room after that fight for 14 hours before they came and got him. So that's how all that blood got there, sir. That just didn't happen just right then and there, and all that blood just was out there like that. The COs failed them checks that they were talking about to make sure that no inmates is in the room. Them are called health and wellness checks. They got to do them every 30 minutes to make sure that we healthy and well. It's the CO's jobs to make sure that we're alive. That's their job, is our safety, not that it's more than one person in the room. So when he was up on his rack, that's how all that blood got in there. He was in there for the whole night. I didn't even know why his bunkie didn't even report nothing to a CO. Like that, I would not, if I felt like it was something wrong with my cellmate, I would have said something. I wouldn't stay in a room all night with somebody that's bleeding like that at all. And then not report nothing the next morning. His bunkie didn't even report anything the next morning. It wasn't no cover on him before I left that room.
But he wasn't
even laying down at that point.
But I mean, you knew that he was injured. You could have reported to
Yeah,
him.
but I did not know that he was injured to that point. And me, like I said, being a snitch in prison is the worst thing ever. I've been on J. John 2 years. I done seen somebody be considered a snitch, get stabbed, get 190 thrown on them, 190 hot water thrown on them. So at that point, am I thinking that my friend I didn't see no gashes on his head. I seen his lip bleeding. If I would have seen what I just seen today, I would rather be considered that and him still being here than me being here going through this and him not here.
So what was your level of concern about Weatherington's injury that night?
Well, after that night, after I seen him, he was telling me his head hurt. I go back to my room. I'm just praying. I'm hoping that he's cool. And the next morning.
Well, that's what I want to ask you about, because you told the troopers that when they confronted you about your knowledge of the injuries, and you talked about the information you had, and you said, I stayed up all night praying for him.
Yeah, I did pray for him.
So his injuries were either bad enough that you stayed up all night praying for him because you were worried about his well-being, which you would think then, if that were the case, you would have alerted a CO to maybe go check on him, or you didn't think his injuries were that bad and you wouldn't have been praying for him, right?
No, I was praying for him because the whole time, like I told you from the beginning, sir, from when I entered the room and he was on his cellmate's bunk, all he kept saying was his head hurt. You feel me? My head hurt. I'm like, is you cool? He's like, yeah, give me some water. Even when we put him on the top rack and he was sitting up, I'm like, is you cool? He said, yeah, my head just hurt. So, in prison, I've been in prison. I've been in prison for 5 years, sir. I done seen people, you feel me, getting into fights and stuff. So this is my friend. This is somebody I eat with, somebody I go play basketball with, I do culinary school with. So of course I'm praying for him all night. I don't really know that I'm not in the room with him. I'm not in the room with him overnight. I'm not with him. So at the end of the day, yes, I was worried about him.
Why couldn't you have, because you talked about this before, one of the COs talked about it. I understand the concern about snitching, right?
Yes.
I think everybody understands that. But what the CO said and what you talked about earlier is you can make up any number of excuses to tell a CO to come into a cell and just do a check, right?
Mm-hmm.
If you were concerned about the injury, why didn't you tell Wetherington to make up some excuse to get a CO to come talk to him? Why didn't you do that? It didn't have to be, I just saw James Ogletree smash my friend in the head. You could have come up with any number of excuses, innocent excuses, right?
Sir, like I told you before, I'm not on that side of the range. So me coming up to a CO, and I'm not even on that side of the range. I was just out of place. I just seen a fight get taken. So me going up to a CO, making up anything, how would I be able to do that if I'm not on that side of the range and not even supposed to be over there? If anything, I was thinking if it was that bad, I'm thinking Addison would have alerted the CO that night or that morning.
So this is on Addison. He should have alerted the CO.
If that's your cellmate and you staying in the room with him overnight, you know him, you're in there with him for 14 hours. If you ain't say nothing that night, why ain't you say nothing that morning? This is your cellmate. I did not know that anything was wrong with him overnight. When the last time I seen him, like I told you, he was responsive, he was alive. So I'm not thinking that he's even about to pass away or nothing. That's not in my mindset. Why would I even think like that?
I don't know. You were praying for him all night.
So that's me thinking that he's about to pass away, that I'm praying for him. Yeah, my friend told me that his head hurts. I'm going to pray for him. I don't know the extent of his injuries. I didn't see no gashes or nothing. He just was telling me his head hurt. I seen his lip was busted. You feel me? But I did not see nothing like too severe or anything like that for me. So yes, I go back in my room and I pray for him for the night.
The next day, what knowledge do you get about his injuries?
When Addison first comes out, like you seen in the video, I'm asking him, when I see him, I'm like, is he cool? When he goes by the trash can, he tells me, like, I don't know if he's cool. So instead of me, like, being considered a snitch, I know he's the cellmate. So I know they're going to come to him. So my exact words to him, if they come to you, make sure you tell them to come get me. And I told the Highway State Patrol that as well.
So it's your testimony that even that morning, you didn't know how significant these injuries were?
No, he just told me that it wasn't like he don't know if he was cool or not. So I told him if they come and get him to try to talk to him, can you tell them to come get me? Because I didn't want to be considered a snitch if I go up to the CO and everybody can see me talking to the CO. So I told Addison, if they come and talk to you or come get you about a fight or anything, can you tell them to come and get me?
So when Mr. Hakeem testified, you heard him testify that morning you guys are doing laps at rec together, right?
I never did no laps with him.
Because he was trying to give you a little bit of grace. He was talking about the remorse that you expressed for being involved in that.
Yes, sir.
You're saying that didn't happen. You didn't express any remorse.
I never even see Addison and Hakeem is in the same gang. So when the stuff came up missing from the day before and Wetherington thought it was him that took the stuff, thought that Addison took the stuff, thought the GDs took the stuff. I never really talked to Hakeem ever. So for him to come up here and even say that, you never seen us on camera having no conversation.
So that was completely fabricated.
Yes,
that whole discussion that next morning.
I never. Do you guys got that footage?
Okay.
Mr. Knippen, how much longer?
Couple minutes, Your Honor.
What he said was in my.
Hang on.
So let me ask you this. Again, you said your main purpose, make sure he doesn't get jumped, hurt too bad, make sure his stuff doesn't get taken.
Yes, sir.
Let's talk about the stuff. The mesh bag that you removed from the cell, you never took it back.
I never got it back from the room that I put it in that night because we locked down. And after I checked up on him and stuff, I wasn't worried about hurrying up, putting anything back. I was just trying to check on my friend, honestly.
So this bag that was so important that Mr. Weatherington was willing to fight over it. You were willing to grab it from a heartless felon. You never return it to the victim in this case.
Well, honestly, sir, they took all his commissary like I told you that day. What was in that mesh bag was some little stuff that he had left. So when they was in the room, like I told you, and he was like, y'all stole my stuff. Y'all didn't even take it. And he was like, I take this. It wasn't really even nothing in the bag at all, for real.
Well, you talked about in your interview with the Ohio State Highway Patrol that there was food in that bag.
Yeah, I just told you that. It wasn't nothing much in that bag, honestly. They took all, like his commissary, like his main commissary, they took it. It was some glasses in the bag. It was like a couple of soups left in the bag. So it really wasn't really nothing left in that bag.
What did you do with the food?
I like I told you, I set it in my next door neighbor's door. Once I set it down in there, I walked back to the room. Once I walked back into the room and the fight and everything went on, after everything, I went back downstairs, looked for Addison. The bag and the food went out of my whole entire thing when I was just trying to make sure my friend was cool. Like the little stuff that was in the bag, I wasn't even thinking about it, like honestly.
Did you give the food to anybody?
No, I didn't give the food to anybody. Well, I dropped the bag off to the room next door, so I never got the bag back from the room next door, so they must have took the food.
Isn't it true that you told the trooper that you gave the food to Weatherington's roommate?
I don't remember that. I remember I gave Weatherington's roommate a soup from mine, but not from that bag, sir. That bag never even went in my room.
Well, we'll play a portion of a clip and we'll see if it refreshes your memory.
All right, I need to take a break. Ladies and gentlemen, we're going to take a quick break. This has been an hour and a half. So I'm going to send you back to the jury room and just take about a 10-minute break for right now, okay?
All rise.